Yes, Mr. Patel.
Quite interesting for me after
Yes.
the content of my planet body. Item number. Yes, briefly in one letter. The
Bill number?
very tricky question of fact and law intermingled with each other. If I can get at least 2 days time to go through the brief, I know I am embarrassing your lordship by this after knowing all this. This. It would have been real privilege for me, man, because the peculiar tricky questions of facts and laws are all mixed up. A very interesting case, probably. I have not seen the record, what I have learned from my dad. Thank you, Lordship. Convenience. I am going to come back after I read the file.
Oh, this matter.
I talked to Mr. Sorry, madam. I apologize.
How can we have it tomorrow? Matters need to be finished. We don't say matters to be finished. Mr. Pathak, I don't grant adjournment for silent. You are expressing your immediately, okay.
I'll try to read the file today.
Tomorrow
God bless you.
at 2 p.m.
I have tried it. Difficult to account for one. I have filed an affidavit in 7th of March, but it is not on the record.
They have a copy of it.
I have the copy. The order, the entire order is because it is not typed. Because
I can read it.
For public. May I please? I have filed one file for releasing of the money deposited by the insurance company. So my tomorrow, but
5th of May.
5th of May. It's a medical related doctor.
Item number 10, FAO, no adjournment. FAOs have been required to be finished. Next. Not necessary. If we admit it, then we take.
Chief, I beg to mention 2 items, one second appeal and one MEC appeal for orders on Monday, 28.
Right.
I know some urgency, there's an order for
These are urgent.
listing the case for hearing.
No, you could file an application for link. Matter has been fixed for hearing, it will come up for hearing.
It is not fixed.
Mention for hearing stage matters not permitted.
It's not fixed already. It needs to be fixed.
So we'll have it later on 14th of May.
On 30th of April.
Why?
Orders have because the appellant till now not deposit the 50% order.
There was a direction.
Yes, direction is there. But till now they are not.
There was a direction, so there is no stay. Go ahead. Go for execution.
I have got it.
They have not deposited.
And then so Nidhamik on 30th of April and lots of 30th of April.
14th of May.
Okay. My lord, they filed the application of the service. They allowed.
I beg to mention item number 36 for orders, my lord. One of them may be granted for taking steps, my lord.
What?
My lord,
No steps taken.
sole responded, my lord, issue notice on 6/12, but I have not taken steps, my lord, earlier.
Why? 2024 matter, you have not taken steps.
Sorry, my lord, only one will tell you.
Okay, we impose a cost whenever the matter reaches. Even when the matter reaches, we have not taken steps.
Three NSC appeals dismissal for order. The fixed last on 6/5/2024. From the appeal today, the case is not listed. So finally,
Seventh of May.
and then can it be some 6th May? So I'm from looking for on the 6th May, I have.
So we have it in the month of June. When do you want to? 4th of June? Prepare yourself.
Yeah. Earlier, day,
4th of June.
that's earlier day, but it's 11th. For motion item 1.
Wait, Mr. If you look at the file window, I have finished the entire order sheet. Along with below that copy of the plea, as per your lordship order below. Here it appears below. In the first order sheet, the case was registered on.
Where is the copy?
Yes.
Give me a copy. You have a copy, extra copy
The
or
only
not?
copy that I have read now some important points below, Dr. Kindly please. Because it was earlier registered before the civil judge of Nagaon. Then it was transferred to Milord, Munship number 1.
You are
The second
telling me
order
what?
seems to-
You wanted an amendment application. Amendment to be allowed.
Yes, yes.
Huh?
The amendment regarding one date only. That is in the main, our CRP report, CRP 16 of 2025 report. That was only regarding one point, date. Difference is only 1 month. Below. Instead of 2000, it was, it should have been 25/08/2023, but it was written as 25/07/2023.
Which is your amendment application?
At page 19 of the CRP below.
The petition, dependent number 1 begs to state that she has filed the petition on the order 9/7, graduate section. Copy order dated. Paragraph number 1, the written date of the day. Now, what is the date of the- This application has not been, what has happened?
Not considered below, because in the order, if in order, below, it is not reflecting anything, whether it is allowed or. Secondly, my lord, regarding the service, first, my lord, it was before the civil judge. Then it was transferred to my lord Munship. But before the civil judge, my order was 6/2/2020, my lord, the second order. It appears, my lord, that defendant number 2 appeared. And he received my summon, my lord. Because the address, my lord, wrong address. It is my original address. I am residing at Dekargaon, Tezpur for the several years. I have annexed the plain in my affidavit below. Wrong address. This is my original address with my father's name. It's okay. But I am residing for last several years in Tezpur, my lord. In the plain, it appears, my lord, that the address is given wrongly, my lord. Knowing it very well, it's a brother and sister, my lord. He knows everything. And in between that, during COVID, this is COVID period, this petitioner went to, my lord, Bangalore also. Or sometimes he was in Bangalore also at that time, my lord. But ordinarily she resides at, my lord, Tezpur, Dekargaon. As per order 5/20 and sub-rule 1, my lord, this, my lord, process has not been completed.
What's wrong with these courts? They are not allowing this. They are to make it corrected and then
Yes.
they are upon the procedure with the order 9/7 application. What is wrong? Making it
Secondly,
unnecessary.
main thing is, my lord, regarding the ex parte order.
the ex parte order, and that itself the plaintiff has given wrong address. This is not my address, because for last several 20 years.
What was rejected by this order, routine order?
Routine
what-
order without considering why they have, because in my, I have one,
Mr. Goswami, what are the two applications which were rejected? Your ex parte application was rejected.
and this order, 6 Rule 17 order, application below. And nextly, my lord, I have clearly mentioned in my annexure 1 this objection that order 5 Rule 20 is not followed. Because they will have to affix my this summon or notice in my residence, my lord. They have not done. Directly they have published in the Times of India. Whereas I have annex 1, my lord, certificate also. Times of India is not circulated in Jakarta test book. Therefore, it is absolutely may not to suppress or to make ex parte. They have, my lord, planfully, they have, my lord, filed this complaint, this my lord, claim. I have annexed the plaint also, my lord, in the affidavit.
Mr. R. Goswami, we finish it off as early as possible.
Yes, my lord.
These type of matters can be.
I have enforced the entire orders because it appears that the Honorable Trial Court has not complied with the provision of Order 5 Rule 20, Sub Rule 1.
Mr. R. Goswami, in the issue notice. When is the next date fixed?
They are
When
no
is the
com-
next date fixed? Before
next
the
date,
trial
my lord,
court,
I will have to ask, my lord.
ask again. Why why don't you come prepared with everything? Ask. We'll take it up after some time.
Step 2.
Yes, what is this?
So basically, what the pages, eviction or issue was the trial court.
Huh?
But it is traditional, it is dependent. That will appear in the court of notice, the number 3, complete quality.
Which order you are challenging? Page?
Page was 12.
What do you decide?
Process, I am referring to.
Then?
Only the still that was the property, the.
One property is situated out there in Kamrup Metro.
No, no.
Yes, schedule A.
Schedule A then is it? Schedule
Then?
A then, the PMC has different,
ENC is different, maybe. So what?
so PMC was a present for in the schedule of income from the metro.
So,
They were
so he has to file 2 suits for partition.
released for in the metro.
Huh?
For the paper,
What is the relief sought for? He is asking for partition.
partition and lot, yes. And
Then?
didn't they declare partition of the civil property, 1/3 share between the plaintiff and the defendant. And isn't the
precept of the revenue authority for partition of the civil property within the property dependent. I have final decree thereby determination of equal one-third share of the each of the plaintiff and defendant from the property mentioned the civil property.
So, what is wrong with that order?
As per section, the one is trial court, related upon the section 17. This section 17 basically says, if the portion of land fall within the and the trial court has related to section 17 of civil. Section 17, what I have understand of section 17, it says that if any portion of land, the civil property, falls within two or several districts, then only the option of the parties to opt either to dispose. Here, the civil property doesn't fall into different. They are independently fall into different.
So what?
So, district.
So you say that half of the property should be situated in Kamrup rural and half in metro? What do you want? Dismissal or withdrawal? Either of it.
Kindly, I will do the order.
No, nothing.
Also, kindly see the order of the honorable administrator. This is clearly covered in this case. So starting from the fact of the case. Case number was 3.
Huh?
Logic, first starting the fact is at page number 3, para 2 logic.
Then?
Then logic come to page number 13, para 29.
The council, this is misgender of other action. There is no relevance.
Civil property also.
No, show me the plane.
With the fact of the case and
Show
fact of
me
my
the plane.
case. Then starting from this starting 14. In page number 16 was the fact, paragraph number 3.
Which one? Dismissal or withdrawal?
Also considering my judgment of this affection or pardon.
Has Mr. J concerned the limit council if it out of it? Push. Regional jurisdiction under section 115 of the Code of Civil Procedure 1908 or short have been invoked to challenge the order dated
18 to the
dated 18/2/2025 passed by the Learned Court of the Civil Judge Senior Division number 3 Metro at Guwahati, hereinafter referred to as the Learned Trial Court in title suit number 243 of the 2023, whereby the applications were filed for dismissal of the suit on the ground of want of territorial jurisdiction in petition number 4848 of the 2020. This court has duly perused the copy of the claim which have been enclosed as Annexure 2 to the petition. From a perusal of the claim, it is seen that the defendant reside within the jurisdiction of the Learned Trial Court. Further to that, we've also taken note of that out of the three properties wherein partition have been sought for, one of the properties, that is Schedule A property, is located in the section of the learned trial court. In this regard, this court finds it relevant to take note of section 16 of the code, wherein it is stipulated that in respect to wherein it's stipulated amongst others, that in respect to a suit for partition of a immovable property, it shall be instituted in the court within the local limits of which jurisdiction the property is situated. The proviso to the said section 16 further stipulates that respecting or compensation for wrongful removal property held by or on behalf of the dependent may, where the relief sought for can be entirely obtained through his personal obedience, be instituted either in the court within the local limits of which jurisdiction the property is situated, or in the court within the local limits of which jurisdiction the defendant actually and voluntarily resides or carries on the business or personally works for gain. Full stop. This court further finds it relevant to take note of second, section 17, which stipulates that where of the code, stipulates that where a suit is to obtain relief respecting or compensation is situated in court, the suit may be instituted in any court within the local limits of which jurisdiction any portion of the property is situated. Taking into account the provisions of section 17 of the Code of Civil Procedure, it is the Banco have testified in reject application filed for dismissal of the suit for want of territorial jurisdiction. This court further finds it relevant. Before parting with the record, this court further also finds it relevant to take note of the judgment of the Supreme Court referred to by the learned counsel for the petitioner. The case of Shivnarayan bracket D by LRs versus Manikal bracket D, two LRs reported to
From 19 to 15.
2020 11 XCC 629. It's relevant to take note of that the observations and the findings to arrive at in the said judgment has no relevance to the present issue, in as much as the said judgment was passed in connection with, in relation to the rejoinder of causes of action, and not in respect to whether the jurisdiction were not in respect to where the jurisdiction would lie when there are two properties situated in two different districts in a case of a partition suit. Taking into account the provision of section 16 of the code, this court finds no ground to interfere with the impugned order for which the instant petition stands dismissed.
All right.
Take this Yes, what is the next date?
25/4 for necessary order.
Two thousand twenty-five. Steps be taken upon the respondent by way of registered as well as usual during the course of the day as regards the response. In addition to that, the petitioner is further directed to effect service upon the respondent to the state and put it to the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner hearing is that the petitioner that by the order dated 23/2023, 20 bracket 23/2023. The learned trial court had proceeded, learned trial court, that is the court of the learned municipal number 1 Norgao, had proceeded ex parte against the petitioner. Subsequent thereto, the petitioner had filed an application under Order 907 of the Code of Civil Procedure, which was registered and numbered as petition number
2148. 2148/23.
2148/2023 on 29/2023. On inadvertently, when the said application was filed, there was a wrong mention of the date at paragraph number 1 to the effect that the petitioner came to learn only on 25/7/2023, which ought to have been 25/8/2023, for which an application was filed under Order 6, Rule 17 of the Code for amendment of the same application. It is the further case of the petitioner that the learned trial court rejected both the applications, and as such, the petitioner is before this court. This court has duly perused the order sheet of the suit which have been placed before this court by way of an affidavit filed by the petitioner, as well as also have taken note of the order, including the order dated
21/8/2024. Page
21/10/2024. And is of the opinion that the petitioner has been able to make out a prima facie case for stay of the further proceedings of title suit number 324/2021 till the next date. According title suit number 324/2021, title suit number pending before the court of the learned civil judge junior division number 1 Norgao can remain stay till the next day. You have to. Why you have moved this court to the delayed manner?
My lord,
You filed this on 3/1. The meantime, the suit has proceeded. So you,
for cross-examining the last day.
very well, very well. So you have to pay compensation. 25,000. 35. 35. It's very poor. It's I don't like it, you know, 35. Or you are appearing, you pay it from your pocket, you are a legal lawyer. Pay 35,000. You ready? You are a rich lawyer, you pay, because moving so late, you should have moved the court
I have
immediately.
received late, because I have received late.
You couldn't have received late. You were represented by a counsel. Why are you saying that you have received late? The order was passed on 21/10/2024. Why you have approved on 3/1/2025 and thereby allowing the suit to proceed in such a manner? It is absolutely your fault. 17,500 upon Mr. R. Goswami and 17,500 upon them. This is the amount which you. Next day, so I am allowing you till 9. Till 9. Get your things ready, both of you.
Attempt 3.
Yes, what is this?
Was the quick. It was the quick. Specific performance contract. Page 34, the operative part.
Huh?
Page 34 is the operative part.
Why is this a CRP?
The execution case has been discussed. Execution case has been discussed.
Dismissed. Why?
My agreement for the sale, the original agreement, the contract has been resigned.
28. Because there was the time being given to you.
3 months. Before the 3 months, he approached the trial court, the executing court to deposit the money. The learned executor verbally asked to deposit straight to the defendant, judgment approved. In the meantime, he has already expired.
What was the direction given by the
So
clerk?
within 3 months to deposit the remaining balance.
Where is the direction?
Page 34, madam. Last portion, the fruit of the plaintiff is decreed partly on contest with clause.
Directed to pay the balance consideration amount of the month to the
20,000.
defendant.
Ah.
To the defendants within
ma'am.
3 months.
The defendant, there is a sole defendant, my lord. He expired after the argument of the case. The suit, my lord.
Then?
He could not.
So
find
why
it.
didn't you file an application?
There was no file.
Then?
My lord,
Over.
eh,
No case.
No, my lord. There is an application stating everything in details, my lord.
Huh?
There is an application file, my lord. If your lordship come to page. Page 51, my lord. The type copy.
Approval of the case record reveals that no such steps was taken by the plaintiff to pay the balance amount within 3 months. However, on 31/10, when was the judgment decreed?
It is 14/9/2014, my lord.
14 September.
14/9.
So you completed 3 months on
No, before that,
October,
my-
November, December.
Yes, December, it has been completed, my lord. Before that, I have gone to deposit the amount in the court, my lord.
Where's your application?
My lord, page 51, my lord.
Page
51.
Yeah.
Para 2, my lord. That the decree holder deposited the amount in the court, but the court verbally directed the decree holder to pay the amount of.
You filed it on 29/3,
Yes, my lord.
much after.
Yes, sir. Within the specific time we have filed. my lord.
No,
Kindly come to the my lord, para 2, my lord. That the decree holder deposited the amount in the court, but the court verbally directed the decree holder to pay the.
how did you deposit?
Who?
How did you deposit in the court?
Yes.
How? How much was the amount?
80,000.
Then how did you deposit before the court? There was no direction to deposit before the court. What is wrong?
Then in the, no, my lord, the argument of the case took place in the way back in my lord, in the month of August 2015. And,
Whatever may be, I'm not concerned with the fact. Concerned is 28 is done.
so, my lord, the interesting part is, my lord, an application has been filed under section 28, which has been dismissed, my lord. The defendants, the legal heirs of the judgment debtor appeared in the execution proceeding. They filed an application under section 28 of the specific relief act. This has been dismissed
Why?
for the part by limitation, my lord.
Why?
Page 61 is the, my lord, the application, my lord. And 1/8 is the order and the operative part is, my lord.
It
83
was filed subsequent
was filed by the legal heirs of the judgment debtor.
after 7 years. So
So it has been-
that was in fact not necessary.
In the meantime, my lord, same ground has been taken in the execution proceedings, my lord. And if your lordship come to the
Go to.
page 96 of my application. Of the execution process.
Slightly. Okay. Okay. You are directed to pay, you have not paid matter.
My lord, under section 28(1), the time can be extended, my lord. It is
Yes,
because
but
we-
you have to apply.
Verbally-
You applied subsequently.
Learned
Show me a
execution-
judgment wherein it is permitted that time can be extended after the period is over.
That has not been there. It's true, my lord.
Because there are judgments otherwise.
People also timing.
No, there are other judgments.
For page 96.
Yes.
The judgment was paid to resign the agreement dated 26 and executed between the plaintiff and the original defendant in excess of the power under section 20 of the Civil Act. Earlier also they have filed an application registered and miscellaneous to oblique benefit. That has attended finally. No challenge has been made to that.
Not necessary.
Now
That
on
was,
the
that
same
was,
ground,
that-
my lord,
that was done so because there was a delay of 7 years. And section 5 would not apply of the Limitation Act. That was the reason why it was done. Now, here is a case that the 28 is over. You have not done it.
my lord,
No case.
at least, my lord, can be remanded back to prove that whether we are represented or not. Full
What?
leading evidence.
Why?
Prove that we have deposited the amount.
You should have taken that option. File a review application there. File a review there. You want to adduce evidence. Not the case here. Liberty for what? Review. Why should I give you a liberty? You already have the ground of review. You have to file it. When was this order passed?
Was page 87.
12/11/2024. And you are approaching another 5 months, 4 months now. Yes.
We have filed from
When did you file?
well before the limitation.
No, I'm not on there. Why have you approved so late? The limitation for review is over. File review, condemnation done. You want to adduce evidence? No case.
Some observation, my lord, will be drawing by.
What?
Observation.
Permission for what? You file, you know, you, both of you are expert counsels, who there? It is unnecessarily putting out here unnecessarily matter. Showing it as pendency. Whatever cases, you were supposed to deposit within 3 months, you have paid. Okay, you may ask for time to the trial.
28(1) is very interesting.
When your application is asking for time,
It's not there.
then without that being asked, that court, the trial court has the power to extend it, but the executing court cannot do that. Your mistake is there.
My lord, moreover, section, the application under section 28 cannot be decided in executing. Cannot be decided in an executing proceeding.
No,
It can be decided in an original jurisdiction.
no, the executing court has not made a mistake. There was a direction to deposit within 6 months, within 3 months. So the executing court has to follow the decree. You had to file an application before the trial court. Maybe it is the same, but in the trial proceeding, they kindly extend me, which you have not done.
Was not done in the written, but verbally, we have.
Verbally
I
can do what? Then, no case.
Some observation. Otherwise, my lord, all the hard-earned degree will be go.
Pardon, degree doesn't happen because what were you doing from 2016? 16 is the degree, 15 is the degree, we are in 2025, 10 years down the line and you want to just pay 80,000 and get the land?
Moreover, there is also, my lord, the legal
That is
layers,
the reason why.
legal layers of the, my lord, the defendant judgment debtor also will be placed.
But that is why you should have filed an application. One has to be vigilant.
No application to be done.
The so and so, the learned counsel supports that you not like to press the instant application. However, he supports that the withdrawal of the instant petition shall not affect his right to file an appropriate application seeking the extension of time from the learned file court, which were advised. Taking into account the above, the instant petitions from withdrawal was delivered the blue petitioner with the liberty to approach the learned file court, which were advised. Upon such application, we file the learned file court shall adjudicate the such application in accordance. What it is? What are you challenging?
Order dated 21 by
Page.
page number 27 and exit 3. The order is reflected over page 27.
Page 7.
And exit
27 is what?
27, the order 22 to 27, and the order is reflected over page number 27.
What is that order?
The order is that the petitioner was directly paid rupees 4,000 per month as maintenance spending line and 15,000 as his expenses to respondent. The section 24 of the Dependency.
How much you ask? Maintenance per month to the petitioner, 4,000 and 15,000 granted as cost of the proceeding. Then what is wrong?
Just very important to note that the respondent has already filed it fully. Proceeding and HDL have been paying rupees 2,000 per month as from the proceedings under DPL. And also the assumption is that the petitioner is working as a company teacher under the aegis of state government.
What?
Petitioner, the respondent is working as an company teacher under the aegis of state government and she is earning at most 10,000 to 12,000 per month. Whereas the respondent is unemployed.
Unemployed?
The petitioner is unemployed and he is really subsisting on the pension of his mother, who is also suffering from paralysis and health conditions.
He earns only 4,500 per month.
But fact is that your lordship, according to latest pay scale, it's quite evident that she earns around 10,000 and 12,000 per month. Also, she is offering the benefits under the DPA.
Did you file the assets?
That is the fight. It's reflected over page number. It's page number 85.
Yes, what is your name? What? Gurumoy. You paid 6,000
Paying 6,000 per month.
in the biggest. You're already paying.
We're applying it regularly.
Name of the children, one is 21 years.
One
Why is it required to pay for them?
in 11.
Huh?
One is 21 years, third is 13 years. All the,
Custody, the 21 years is a major.
all the expenses regarding education and their livelihood are already paid by the parents of the petitioner. All the documents regarding the account fixed for them.
So you are with the mother's pension.
Yeah.
You are already paying 6,000. You keep on paying that 6,000. Notice making it returnable on May 2025. Steps be taken upon the respondent by way of registered as well as duty to the course of the day. And further to that, the petitioner is also directed to the service on the respondent through the student, which will still respond and final activity concern. Petitioner herein have extended the order dated 21/2/2025, passed in the case number 43 of the 2024 by the Court of the Learned Judicial District Judge number 3 now. Whereby the said, whereby the learned court had imposed upon, had settled an amount of rupees 2,000 be able to be paid by the petitioner to be paid by the petitioner to the respondent every month as interim maintenance, and further another amount of rupees 15,000 as cost of the proceedings. The learned counsel, appealing on behalf of the petitioner, has drawn the attention of this court that by an order passed in the case number 108 of the 2019 by the subdivisional judicial magistrate bracket M, Nagaon, Kuliabar, Nagaon, an amount of rupees 6,000 is being paid by the petitioner regularly every month, regularly to the respondent. He submitted that these very aspects of the matter where, Sovereign?
Page number. Page number 18.
Huh?
Page number 18, actually.
80.
Page number 80. 80.
80 doesn't say anything.
Section 4.
Yes. 6,000 per month. Sorry. The learned counsel submits that these very aspects of the matter have not been taken into consideration by the respondent, by the learned court, while passing the impugned order. This court, having perused the impugned order and also the affidavit of assets and liability of the petitioner, is of the opinion that in the next stage, there is a requirement of certain protection. Of the opinion that the petitioner requires some interim protection in the next stage. Accordingly, this court directs that in the next stage, the directions so given by the learned edition, court of the additional district judge number 3, Nagaon, in Mize case number 43 of the 2024, to the effect to pay rupees 4,000 as interim maintenance per month by the petitioner to the respondent wherein shall remain stay. This court, however, makes it clear that there is no stay to the payment of rupees 15,000 which was directed to be paid as the cost of the proceedings.
Beg your pardon. They've already paid 10,000.
Right? Of this 15,
The owner she is only obtaining the legal services, all the benefits of legal services. For
okay, you have they paid 10 and pay another 5.
I do oblige.
I've paid the 4.
You oblige.
I. Yes, what is this?
I filed contempt petition. I'm being led by Mr. Chian Saiwala. However, he's next before voting number 1.
What is the order?
Your Lordship, the order is at page number 11. Your Lordship, I'm humbly seeking a short passover.
Huh?
Your Lord, I'm humbly seeking a short passover.
No. You have to do it. Tell me, what is the case?
Your Lord,
Then the nature of the right is allowed to serve notice upon the return to testimony. What is the injunction?
my Lord, the impugned order is in page number 11, effective page number 14 onwards, my Lord.
That's the what is the order. Application to state the operation of the order they could pass with the. Then what happened on 19/2?
My Lord, 19.
19/2/2025, what happened?
My Lord, actually, I'm not briefed in this matter, my Lord. I am Julia from Calcutta High Court. Lord, I've come.
Huh?
My
Yeah.
Lord, I've come from Calcutta.
Very well. You've come all the way from Calcutta, so you should argue the matter.
My Lord, I'm humbly seeking for a short passover, my Lord. This matter is going on in court number 1, my Lord.
Hello, if you were there, I would have issued a notice. But you know, you are not there. Your senior will come. It will be a case for dismissal. You choose it now. Which one do you want? Senior.
My Lord, I'm a creature of instruction.
Okay.
I cannot add beyond instruction.
Okay, we'll take it up when your senior comes.
Supplementary item 52.
Yes. You got the judgment? Which one?
Royalty and other, further Kolamandalam.
So Jayashree says what? What does he say?
Only my
I have it. Tell me.
lord, only my lord, para number, my lord, you must take, thank you. Para number 14, 15, 16 and 18 says, my lord. May I read, my lord, one paragraph?
We are also of the view that in order to maintain a claim today, it is sufficient for the claimant to establish his loss of dependency. Where is that?
My lord,
Where is that in your application?
my lord, will not take, kindly see, the deceased, my lord, deceased and his claimant. Claimant, my lord, originally, my lord,
They were only residing with you. That is your application.
my lord,
Where is your loss of dependency?
my lord, since my lord, I am the, my lord, only legal years, my lord.
No, legally is different. You did not, was not a part of your claim petition initially. You were not, so you were not dependent then. If it would have been dependent, then it would have been different. But where is your statement to the effect that you were a dependent? Show me in your petition before the learned trial court. Then,
Only thing, my lord, deceased and my lord, the claimant also died. was residing in my.
Huh? So what? So what? He may be a tenant. Then,
If he died, my lord, due to accident, my lord, we have, my lord, some loss, my lord. This, my lord, petition says, my lord, the judgment says, my lord,
which one?
I think that it,
I've seen it. That is it. I'm seeing.
my lord, by, FCC online.
That is Sadhna Tomar. I've seen that book.
But here, my lord, says, my lord, in our one paragraph, my lord, small paragraph.
No, no, only one line. Don't read the other paragraph. Paragraph 16 in in that Jayashree judgment, you read it. Paragraph 16, the fourth line from the top. Yes.
Necessary requirements for maintaining claim petitions from claim petition, held sufficient for the claim to establish a loss of dependency and makes it clear that legal.
So where is the loss of dependency?
My lord,
Where you are dependent, where is your statement to the effect?
my lord, statement is not there. My lord.
Then matter over. Okay.
Only thing, my lord, I am the my lord, legal years, my lord.
So what?
Has no
You
other-
were not a legal head during the time when the mother was there, the wife was there. You arrived somewhere from somehow. But it's a huge amount of cost to be imposed upon you for unnecessarily displaying the time.
my lord, only one thing can you consider. My lord, only claimant died. My
So what?
lord, they were residing in
So what? I am therefore asking you, you were not a claimant at that point
My
of
lord,
time.
I have annexed also, my lord, annexed, my lord, legal year certificate.
I've seen it. It was done only the month of after 4/6/2023.
There is a, my lord, John, my lord. My lord, claimant, whole claimant died during, my lord, COVID period. And my lord could not obtain, my lord, legal year certificate.
I am not on the question of that. Why were you not a part of that application? First, secondly, when you filed that application, you should have stated that I was also a dependent. Where is that statement?
My lord, my submission,
I am on 227. I can't do that.
my submission, my lord. Matter may be remanded back, my
For what?
lord.
Go file a review. Go and file a review and show all these things. The court may listen and file an amendment application. That is the best way out. File an amendment. First, you file an application for review there. Show these judgments. The court may not see the fourth line of paragraph 16.
Observation.
And absolutely no. Absolutely. no.
Otherwise, my lord, the entire.
You want to file a review, go and file a review.
Entire case will go, my lord.
So what?
Only simple, my lord, I am withdrawing this petition, my lord, and observation may be given.
What of those? You don't, otherwise it's a case for dismissal.
But only,
As if you are doing some good for me.
I am withdrawing, my lord, on observation, my lord. I review, my lord.
Observation for what?
But I find, my lord, taking, my lord, this judgment, my lord, I will file it.
Heard Mr. Iman of the learned counsel appearing on behalf of the petition. He submits that in view of the judgment of the Supreme Court in the case of N. Jayashree and others versus Cholamandalam MS General Insurance Company Limited, reported in 2022 14 SCC 712, and the recent judgment in the case of Sadhna Tomar and others versus Ashok Soa and others reported in 2025 SCC Online SC 554. The petitioner would not like to press the instant petition, rather would file an appropriate application before the learned tribunal seeking review. Taking into account the above, the instant petition stands closed. The withdrawal of the instant petition shall not prejudice the petitioner to prepare such remedies as available.
Pending item 5.
What happened on 19/2?
19.
19/2.
One of the matter, matter is to say, the Partha is over 12. And that is because of the. We have to.
I'm asking what happened on 19/2? So the interim order was still 19.2. Your WhatsApp message is of 4.3. What happened on 19? How do you know? How do I know? Is it because Mr. Saiwala says? Then withdraw, file it properly if you want to do.
Or I can,
You cannot. Mr. D.N. Saiwala, the Lomond Senior Counsel, submits that the petitioner would be well advised to withdraw the instant petition and refile, taking into account that the certain orders which have been passed, thereby extending the earlier order of stay, have not been enforced. Taking into account the above, for instant petition stands closed on withdrawal. Liberty, however, is given to refile after enclosing all the necessary documents.
For admission item six, part
Madam,
third,
you didn't get that notice because. Yes, what is this?
direction.
Oh, yes. Anything happened?
For that, we have put the application on 11. There, although it was submitted by way of online, we have submitted the offline. Now, what is the best to go that to estimate the matter after 1 week, then 5 of
You kindly advise.
course.
What do you advise?
Trying to upload, but there is no option.
Okay, nothing. They are going to take care of. This the matter, Mr. Tugui hearing on behalf of the. Now you are PP. How can you be both? PP cannot be additional senior. No, because why he cannot be? Because the PP is a neutral position. It's statutory rule. In fact, that was the issue which I raised out there before the, but you'll be there out here because I have specifically entrusted you for this. Okay. Mr. T. Gavoy, the moment, the learned counsel appearing on behalf of the Social Welfare Department submits that he has obtained instructions that the application so filed by the petitioners had been placed. The hard copy of the application filed by the petitioners had been placed before the committee. It will be placed before the committee in a week's time. And the committee would duly consider the same. Taking into account of that, is the matter on 9th of May? Or would you have it on 14th of May? 14th of May for an appeal. You just tell the committee to do it.
Seven.
Yeah, what is this?
it's,
Huh?
it's so the file against me for recovery of. The plaintiff himself claimed is a money lender. Under the Assam Money Lender Act 1934. We prayed for a deputy court to submit it like a certificate issued by the government that he is a money lender. The certificate he has produced is not covered when the suit is filed.
Yes. You are challenging the order 21-7.
Yes.
Huh? What is wrong with that order?
14 to page 25.
Page?
25.
So what is wrong?
Under the certificate is issued for 1 year. Certificate is issued for money lending for 1 year. And his money lending license was expired. After that, he filed a suit. Therefore, he cannot file a suit under as a money lender under that act. If he is not, cannot file a suit as a money lender, then his suit is
It should be.
liable to be dismissed. 7D of the some money lenders act 1934.
So have you filed an application for dismissal?
Yes.
Then what happened?
That this order was page, page 19 of my work.
Let us see your petition.
Page 19.
You are saying about page 19,
Page 19, that is our petition.
but it is, does not ask for dismissal.
The suit shall not proceed in absence of.
You are saying not proceed, but here it doesn't say for dismissal. Then
Yes, but I pray for stay in the prayer. But they
the court seems to be satisfied and asked them to produce it at the time of evidence. Have they produced that document or not?
That document, they have produced, but
The pursuant to the order of 21-7, have they produced that document?
no. Some
They must
other
have produced that document.
That contains those documents.
What is there? Nothing in this.
The court below, having seen those documents, he has concluded that we'll see at the time of evidence.
Certificate of Sushma Gupta, it is there. Ankur Prasad.
Certificate is very genuine, all those things, that is civil code. Appropriate state.
Art Mr. H. Sharma, the learned counsel appearing on behalf of the H.K. Das, the learning counsel appearing on behalf of 1 and 3.
one thing is this.
Yes.
Page 31. They have submitted one certificate,
Page,
31,
ah,
of my additional.
yes.
That certificate is not already money lender set.
Whether it is there or not, that will be taken into consideration by the learned trial court. Why should we go for this now? Push- This is an application filed by invoking the extra filed under Article 2, by invoking the supervisory jurisdiction of this court under 227 of the Constitution, challenging the order dated 15/2/2023, whereby the learned trial court, that is learned court of the Munsif number 1 Dhubri, hereinafter referred to as the learned trial court, had decided to proceed with the suit, being money suit number 02/2021, pursuant to the compliance effected by the plaintiffs in terms with the order dated 21/7/2022 in money suit number 02/2001. The learned counsel appearing on behalf of the petitioner, who is the defendant, petitioner, who is the defendant in the suit, submitted that the suit ought to have been dismissed, taking into account that the said documents which have been produced were irrelevant to the to the context, in as much as Anil Kumar Prasad, as on the day on the date of the transaction, was not carrying any business of money laundering could not have carried any business of money laundering as money lender without license. So, This court, this court, having heard the learned counsel appearing on behalf of the petitioner as well as the respondent, and have perused and having perused the additional affidavits so filed and the documents so enclosed, is of the opinion that the learned trial court was justified in proceeding with the suit, in as much as when proceeding with the suit and to appreciate the said with an observation that such documents would be appreciated at the stage of evidence. Under such circumstances, this court finds no ground to interfere, exercise its supervisory jurisdiction in the matter for which the instant petition stands dismissed, was taking into account. Also, it is seen from the records that by an order dated 15/3/2023, the further proceedings of money suit number 02/2021 was stayed by this court. Most of this, the said stay order is vacated in view of the dismissal of the present petition, and both the parties who are duly represented are directed to appear before the learned trial court on 7th of May, 2025 for further continuation.
Highly.
Yes, what is challenging?
Imperial order is a place. $69 or $70.
Yes. You are the plaintiff or the defendant?
And what's it? I am a conflict. The purpose of the government construction worship. The plaintiff used to apply the construction material. So, as per the claim of the respondent plaintiff worship, he supplied materials to the tune of rupees 27 lakhs 19,011. And out of that, 20 lakh 50,000 was paid by Milos. And there remains 7 lakh 42,011. And for realization of this amount, 7 lakh 40,011, that was the claim amount of the money. Prior to filing this application, worship, against which the impugn order was passed. And application under order 11 Rule 14 was filed. That is an annexure 46, page 46, worship. Seeking direction from me to produce the documents in original from my custody. Against that, I have filed my written objection saying that no, as per the pleading of the plaintiff, the documents which is sought to be brought from my custody is in the custody of the plaintiff. Kindly see page number.
Okay, then,
Page number, sorry,
no, I understand. So, then,
it has been stated that as per paragraph number 7 of the plaintiff is stated, as per the requirement of the defendant, the plaintiff, after supplying the requisite materials at a designated site, used to collect vouchers, material receipt slips from the defendants. So the original is with the plaintiff. And that was refused by me in the against the petition under order 11 Rule 14. But kindly see the petition against which the impugn order was passed. In the petition, there is no whisper with regard to the secondary evidence. Kindly see the petition. Is that page number 62? That is the original one. Prior to that, right.
the petition of page 60.
The type copy is a page lottery. 58. 58.
What type of petition is this? You are seeking leave. You have not asked for secondary evidence. And how is the court pass an order for secondary evidence? One. Secondly, how is the petition only being filed on the basis of a verification? How is it possible? Whatever may be the ground, that is not your prayer even. You are only seeking leave. Interest of justice cannot be at the violation to the provisions of section 65 and 66. Then file you here the court should have been considered, so therefore I direct this petition to be reconsidered again on 10/1/2023 to be reconsidered. Only for the purpose of leave it was sought. The leave was sought for in terms
Those documents were like allotted the plain first. So document which is sought to be called for custody of the defendant. Those documents were filed by the plaintiff. Or is
the things were there. So the question of seeking leave also did not arise. Heard Mr. Sharma, the learned counsel appearing on the. I'll open the learning council if you for all of us. The supervisory jurisdiction of the spot have been invoked. Challenge the order dated 2023. Passed in petition number 19/23. Arising out of money suit number 2022 by the court of the civil judge in Kolkata. Carrying out the record of the learning. Present is in the single. Judge, present judge at Kolkata, presently, hearing after referred to as the learned front. Whereby the said application being petition number 92 of the 2025 was allowed, was not only allowed, but also leave was granted. It is secondary evidence of the same documents have been mentioned in the same. The Honorable and Learned Counsel appearing on behalf of the petitioner subject that the petitioner here, the plaintiff, who is the respondent herein, had filed the suit along with the document and along with the said suit. The documents which have been mentioned in the petition, being petition number 92 of 2023. From serial number Roman 3 to Roman 12. Were filed along with the claim. However, the documents at serial number 1 and 2 of the petition were not filed. These two were not filed. There is no writing of it. There were no file. These are further submitted that in terms with order 7/14/2, there is no mention also in the claim that the documents at serial number Roman 1 and Roman 2 of the petition number 92 of 2023 were in possession of the defendant, which is a requirement as per the code. The learned counsel for the petitioner further submitted that the perusal of the same petition being 92 of 2023 would show that the petitioner, that the respondent, that the plaintiff, the respondent hearing have only sought for leave for submission of the said document at the time of evidence, which under no circumstances can be said to be an application in terms with section for the purpose of allowing secondary evidence in terms with section 65 and 66 of the Indian Evidence Act 1972. In addition to that, the learned counsel further submits that an application, that the petition, being petition number 92 of 2023, require a judicial determination, and as such, and determination. However, the said petition is not even supported by an affidavit, as would be clearly seen from the said petition itself, which is contrary to Order 6 Rule 15(4), as well as Rule 15 of the Code Civil Rules and Orders framed by the Guwahati High Court. Mr. R. Pupon, the learned counsel appearing on behalf of the respondent, submitted, respondent plaintiff submitted that although the petition for filed was not in a proper manner, but in actuality, the said petition was for the purpose of getting some secondary evidence of the documents, more particularly
documents which have been mentioned in the said application. The petition number 92 of the 2023. He therefore submits that in exercise of the powers under Article 7 of the Constitution, this court ought not to interfere with the said order. This court have really given an anxious consideration to the materials on record, including the materials on record, including the petition being petition number 92 of the 2023, dated 10/1/2023, as well as the interim order dated 2/3/2023, passed in petition number 92 of the 2023. It shocks and surprises this court the manner in which the learned trial court had passed the said order, thereby permitting the plaintiff to give secondary evidence even without there being due compliance to the provisions of section 65 and 66 of the Indian Evidence Act. It further surprises this court as to surprises this court that the learned trial court even did not consider that what was the relief sought for in the said petition, in as much as the relief sought for in the petition was only granting a leave to bring on record the said documents which have been to bring on to grant leave to the plaintiff for submission of the said documents at the time of evidence. Further to that, this court is also shocked and surprised that the said petition have been entertained, which does not even contain an affidavit, which is otherwise the requirement when an application is filed seeking judicial determination. Consequently, this court finds is of the opinion that the order dated 2/3/2023 passed in petition number 92 of the 2023, arising out of manuscript number 3 of the 2022, pending before of the learned civil judge at Golaghat, now Secretary Civil Judge Senior Division at Golaghat, is required to be interfered with, and accordingly, this court interferes with the same and sets aside the same. This court, however, when before it is also seen from the records that by an order dated 28/4/2023, the further proceedings of manuscript number 3 of the 2022 have been stayed in view of the disposal of the instant petition. The said stay order stands vacated, and the parties who are duly represented before this court are directed to appear before the learned trial court on 13th of May 2025 for further proceedings of the said suit. Before parting with the record, this court, however, makes it clear that the interference made by this court by the order dated 2/3/2023, passed in petition number 92 of the 2023, shall not preclude the petition, the respondent, the plaintiff hearing, to file appropriate application if so advised.
Item 9.
Yes, FAO.
Challenge the other order. That is 21, 24 July. That goes to the granted injunction.
petitioner hearing, my lord, for one interest. Please should kindly see, my lord, page 14, the suit, my lord, PS 70 of 2023. My lord, what the, it is plaintiff sought for in the suit, my lord. It should be kindly come to page 23. One fifth share. This,
So there is an injunction being granted
yes, my lord, granted.
by
I
the
am
learned
suffering, my
trial
lord.
court.
Because when I am the bona fide purchaser, and before purchasing, I have seen all the documents in the malad, revenue court and DC court, and found all the entries of my vendor are correct. Their names are there in the Zomabundi. I have enclosed that malad. And thereafter I purchased in 2019. Zomabundi are there with effect 2018. And malad, after selling, my name has been inserted in the malad Zomabundi, mutated. And in 2023, they have filed a suit. And suit is for
The sale deed in law,
2019. My lord,
why they find the suit so late?
my lord, their claim kindly see page 23, it is important. One fifth share. He claims one fifth share of Sidul Alan. ठीक बीघा ठीक था मतलब Sidul Alan kindly see, my lord, at page 24. Now, Sidul,
Who sold this land to you?
my lord,
Who sold the land to you?
my lord, different number 2, 3, and 4. They are the, my lord, sons of Toileko Pugon. He is the father of the plaintiff, and my father of my husband. Different number 2. Different number 2, husband's father, my. My lord,
It was being sold by 234.
yes, my.
Which 5?
5 is a minor sum.
Your,
Yes, different number 2.
what is 6, 7, 8?
Deputy
6, 7, 8
Commissioner,
is
Circle
that.
Officer.
Who is 8?
8 is the, my lord, wife of Toileko, my mother-in-law. Different number 2 mother-in-law.
Nine.
Mother of plaintiff. my lord.
The-
9
your
sister, 10 sister.
Your sister, you are filing this appeal on behalf of who?
No, man, I am for the malad defendant number 1. I am the bona fide person.
Have purchased.
Yes. Malad, my claim is here that whether the court below, the order passed by the learned court below, granting injunction is perverse on the ground that the plaintiff claimed for 1/5 share. And total land is, my lord, 3 bigha 3 katha. And he has sought for injunction where the land has been sold against the Schedule B. That 1/5 share, more than 1/5 share land is there in the Schedule C, my lord. My lord, Schedule C is 24. 1 bigha 3 katha land is already there. So it is, in a humble submission, that injunction could have been against the Schedule C land, my lord.
Why?
Because his claim is 1/5 share of Schedule A land.
3
Schedule,
bigha.
hello?
3 bigha.
Yes,
He has no other claim.
no other
What
claim.
is Schedule B?
Schedule B, that the land I have purchased out of the Schedule A land. And Schedule C remaining land, my lord, at best 1/5 share, my lord, his share will be 3 katha 12 lesser. And more than that land is there, my lord. And I have done all the exercise, my lord, kindly see. Page 51, this is the Jomabundi, my lord. This type copy 51, my lord. Order of Circle Officer dated 29/6/2018. Partition number so and so. They have received notice and partition. The plaintiff. Land measuring 3 bigha 3 katha covered by DAG number 12 is allotted to as Myadi Pata in favor of Rupa Fukan. Defendant number 2, my lord. Wife of Diganta Fukan. Elder brother of plaintiff, my lord. Page 51, my lord.
Elder brother of plaintiff.
Yes. And Simoti Doli Fukan, daughter, Diganta Fukan. Toilojit Fukan, son. Hello, this mutation was in their favor with effect from 29/6/2018. I have purchased, my lord. In fact, I have, my entry is also there, my lord.
last two paragraph, madam, 15/10/2019. And my lord, 17/10/2019. In respect of 2 bighas of land, my lord.
Okay, Mr. Som. He wants to raise construction.
He was to raise for,
You have got an injunction.
yes, lord.
You give an undertaking that you will indemnify him for all the loss, which we quantify it to around 30 lakhs. If you lose the case, against him, pay him 30 lakhs. Give an undertaking before the court.
That,
No, you have to give, because the question does not arise. Question does not arise because of the fact. In terms of section 44 of the transfer of property act, he has a right to sell. Any owner has a right to sell.
in that case, lordship, the vendor, he has already filed a suit paying for declaration of right title and interest of the schedule, two cut. That is also pending.
That is, I'm not bothered with that. I'm concerned with this. That's in terms of section 44. A owner can sell.
Yes, yes,
Your right is only limited to 3 kathas.
correct.
As per your own case,
3 kata 12%.
1 bigha is already there.
Yes.
Why should there be an injunction?
Lordship, that defendant number 2, who is the vendor of the present petitioner, your lordship, she has filed a suit for declaration of right title and interest of the title land, which was sold by her to the petitioner. And your lordship kindly see,
No, but in that case, have she obtained an injunction?
that is pending, your lordship.
That is okay for that. Why you are taking the brief from your opposite party? Are you not
I think,
making the dependent
lordship,
number
let's
2 a
see.
party?
The lordship, the vendor who has sold the property to the petitioner, your lordship, she did not have the title over the suit land.
Why?
Yes, your lordship, for paying for title, she has filed a suit that she has, lordship, kindly see, your lordship, page 19. Suit was for, my lord. Page 19, your lordship.
Disturbance by the plaintiff. Sorry.
Lord, kindly see the page 16, your lordship. Page 16, your lordship.
Yes.
Paragraph 6. That the defendant number 2, Srimati Rupa Phupon, filed a title suit in the court of Munship number 1 at Tribhuvan, bearing title suit number such and such, and upon perusal of the plate, it has come to knowledge of the plaintiff from Srimati Rupa Phupon, the defendant number 2 filed his suit showing an allegation there. And in that suit, your lordship, she prayed for. Prayer is page 19. Prayer is page 19, last paragraph, your lordship. The plaintiff's paid for declaration of right, title, and possession over the suit land. What happened, your lordship? The total land measuring 3 bighas, 3 kotha was the absolute owner of what Troilukko Kupon, father, and Troilukko Kupon leaving behind 5 legal heirs. This present respondent, petitioner's husband, and wife of Troilukko Kupon, and 2 others, sons and daughters. But from the pleadings of the Rupa Kupon, it is seen that she has declared, she has sought for declaration that her husband is not known for about 7-8 years, and she sought for a declaration that particular 2 bighas land. 2 bighas. 2 bighas is not will not be paid in the share of that Rupa Kupon.
Who is Dolly Pupon? Dolly Pupon?
Dolly and Nomi and Vinita. Dolly, Lordship. Dolly, Rini, Soilodi, and Rupa. These four defendants are legal, so-called legal heirs of Diganta Pukon. Diganta Pukon will get one share of. Diganta Pukon will get one share of, not 2 bigger kilo. 3 biggers, 3 kata will be divided into 5 shares. And this particular Rupa Pukon, Dolly Pukon, Rini Pukon, and Soilodi Pukon will get only 1/5 share out of 3 biggers and 5 kata. But she sold 2 biggers of them.
The others are not coming before the court.
Yes, they are not. They are not coming, but I have filed a suit, your lordship, for 1/5 share, your lordship.
You have only asked for 1/5,
Yes, yes, I have only asked for 1/5.
so your 1/5 is there.
One bigger chicken.
Let them construct. Tomorrow if you do this, you give an undertaking. Give an undertaking, then you give it to the plaintiff and others, all the others. Any construction made shall be subject to the outcome of the suit. Without there being any further degree. File an undertaking. It's free. When they have passed an order, yesterday only, that's hold of Mr. S. Sound. That undertaking is to be given to the defendant. Now, the others have not challenged it. 8, 9, and 10.
Yes, yes.
Either they want to transpose themselves to the plaintiff, a day before the suit,
So before, at present, I am the only plaintiff.
are 8, 9, and 10 willing to, have they filed a written statement?
They have not, madam, but the defendant who has filed a written statement stating that madam is 65, para 19. Madam, she said that during the lifetime of their father-in-law, her father-in-law, the father of Diganta Pukon, and plaintiff, he madam, divided the shares of the land, their father, and this particular portion of the land given to the builder one, Diganta Pukon, and the other land in the tea garden. They have some other land in tea garden has been given to the plaintiff. So this is the statement in the written statement.
What has the 8, 9, and 10 done before the learned trial court?
My lord, they are, my lord, pro forma defendants. They have no claim. They have raised still that no claim.
You are in good touch with them?
My lord, they said, my lord, they are not interested with this land. This is the case.
Let them file their written statement. Must be in good terms with them. Make them file their written
Prosecution
statement.
is suffering, my lord. At best, he can get,
No,
my
no,
lord,
there's no suffering. There's no suffering. This is the suffering which will other take 20 years. So if you want to lessen it,
yes.
ask your former defendants to support your defendant number 2. You file a written statement and then come up and bring the matter pending. In the meantime, you file their undertaking. And in the circumstance, the construction is made by you, you are allowed to go ahead with the construction. There would not be any further decree required in the suit for demolition. And further to that, now there are many orders which I passed. Construction, I give the permission, provided this is the undertaking. And if the plaintiff wants, the plaintiff will give him the relief. Win the case. If you are sure to win the case, no problem. You know what to do. Mr. We admit the appeal, huh? Tell me what they. Appeal is admitted. Because there is no requirement for calling for the records in as much as the entire record, the photocopies of all the documents are placed before the spot. Photocopies of the documents which have been filed before the learned trial court have already been placed before the spot. This is the matter. Again, of May 2025 for further hearing. In the meantime, the appellant is given the liberty to file appropriate undertaking. That all. And there's the judgment also given by May in 2025. It is reported in ZLT on this aspect. Okay. And in the meantime, get the statement of the proposal defendant. Whoever is more powerful.
Even though we filed that, we will file one additional affidavit placing on record under the before the honorable.
Yes, yes. Has to be by way of an affidavit. And it has to be by, it's a company. Isn't it a company? You need a resolution first. Resolution giving him the power to give that undertaking. Then will be your. This is how you file. Otherwise, tomorrow you will say, oh, this person has gone, we have no.
Item 10.
Need that judgment in 2025. Ask Mr. Sahu or Mr. A. Iqbal. Yesterday they were suing me. Yes, Mr. R. What are you doing?
Settle under 43(1) R. Before coming to interim order, exercise, I may be allowed to show extra from the.
What? Annex under the prayer for granting injunction is allowed for just the Nima, the intent order is made absolute, the intent. That's what is wrong. Who is in possession?
No, no, so plot is actually different. That is why I may be allowed to show some facts from the plan.
I proceed.
No, that I was allowed to limitation of that.
What am I going to do with this? Appeal?
Already allowed them.
What am I going to do with this appeal? What do you do? What order can I pass? What order can I pass? Need to set aside. Set aside after 10 years.
Kindly there is tax.
You're not asking for stay. No,
This is something different.
you're not asking for stay. So let me the appeal call for a record.
This was, the order was only for different plot of land. Here circular.
Understood, but what is the requirement? This is an appeal under what? We are reviewing the PPT. Is order 43, rule 1R. What is order 43, rule 2?
Yes, that is also there.
What is there? Order 43, rule 2?
Order 43 rule to say the rules of 41 shall apply.
So your appeal memo has to be in terms with order 41, rule 1? Which is in terms with the appendix? Where is the prayer?
Judgment of Honorable Supreme Court is there. So stay is not connected with main appeal in all cases.
Very well. I'm saying that. I'll admit the appeal. Call for the records. No one. I'll admit the appeal. He is also happy.
Yes, sir.
Yeah, we'll issue
It is
notice.
some act of-
We'll issue notice, admit the appeal, matter over. He's not going to help you. Trying to help you does makes you want to show the Supreme Court judgment. Well, sorry.
This is
You are paying for whom?
the and for the
How many? Where am KV? Don't appear. Don't appear. Don't appear.
Kindly allow me to.
No.
Yes,
No,
please.
I'm admitting it. I can't pass an order in absence of them. Heard Mr. R. Ali, the learned counsel appearing on behalf of the appellant. Who's- There's an appeal filed under order 43 1R, read with section 104 of the Code of Civil Procedure 1908, challenging the order dated 31/5/2022. Isn't that? 31/5, nah? Isn't that order?
Sir, 6.
31/5/2022, passed in Mize case number 24 of the 2021, arising out of title suit number 17 of the 2021. Appeal is admitted. Full stop. The scan copy of the records of the injunction proceedings, that is Mize case number 24 of the 21, be called for from the learned court of the civil judge Bongaigaon. Mize case number arising out of title suit number 17 of the 2021 be called for from the court of the civil judge Bongaigaon by the registry and placed before the court. Full stop. Steps be taken against the respondent numbers 127 by registered as well as usual. And why are you filing an injunction appeal now in the year 2024?
23, matter.
23, why of an order of 22?
So, the petition, appellant is about 80 years of.
So what?
Sir, there.
This has gone for a 6.
Case is totally exceptional.
So what?
I not required stay order, totally different type of case.
Maybe
That is
there's nothing I can't help you. I can't pass an order in absence of the other side.
11. And
Yes, what is this, Mr. Gupta?
This aspect is also that, claim application was by the.
Then what happened?
Lordship,
Service complete.
lordship from the lordship stays there.
Let's decide it. Argue.
Here, my lord, the incident took place on 14/6/2022. And the claim application was filed on 14/6/2022. But there was
27/12/2022. After 6 months.
after expiry of 6 months, there was enough 16 days. in filing the application. Now, lordship, at the time of filing the claim application, my lord, payment side has also filed one application under section 5 of the Injunction Act. For where order was passed without hearing us, like with no notice was issued to us while deciding that, while passing that order, lordship, order dated 18/1/23.
Then
Thereafter, lordship, the main case started. Notice was served upon us. After appearance, we found that the case is barred by limitation. So accordingly, we filed another petition raising the issue of maintaining it. So that petition was rejected by the current member MSCP. by order dated 17/10/23, with the observation that the issue of privileges has already been decided. Thereafter, we have approached this urban court lordship. Now, lordship, my point is that the Motor Vehicle Accident, Motor Vehicle Act was amended in the year 2019. And there is insertion of one section, lordship, 166 subsection 3,
A limitation goes for.
and 166 subsection 3, lordship.
Yes.
No need of lordship.
No application for compensation.
No application for compensation shall be entertained unless it is made 6 months of the occurrence of the accident. Here, my lord, the accident took place on 27, on my lord, 27/12, 22, and that was filed beyond the period of 6 months. That is, there was a delay of 16 days. Now, lordship, that this amendment, lordship, came
Now,
into
whether 4 was complied with. Whether 4 was complied with.
lordship, that is of course in my not in my knowledge, my lord, because this
No, no, this is the important thing. This is a very important thing. If it is not done, whether 4 was complied with, shall treat any report of accident forwarded to it under section 1459. If it is not being done, then in that regard, can there be a strict interpretation? Because if you are fixing a period within as regard 166(3), then in 166(3), if you are fixing this particular period, then it will have far-reaching consequences. It will violate somebody's rights. Somebody may, just for example, a person concerned, he was the only person who has been in the, where he has been in the hospital. Injury case, suffering. He could not come. Later on, he comes. Are you saying that 166(3) will have that application?
lordship, as far as the language there.
The language is okay, but the language has to be treated in that manner. Just for example, if I remember, you see the judgment of Salem Bar Association. First one. Then it was dealing with the issue of adjournment. I think no, 2003. And it was said that if for an act of God, if it happens, can a person be deprived of an adjournment? The Supreme Court said no, it will violate the constitutional rights with missing. It is a right under Article 21. So there are many cases wherein, in fact, you will see that the judgment in Media One, the Supreme Court was dealing with a particular provision, wherein it says, taking into account that Anata Gandhi was a judgment wherein it has been held that the Article 21 also includes the principles of natural justice. Observe that in order to do so, that this particular provision does not become bad, we are to infuse the principles of natural justice in every statute. Otherwise, it will violate the mandate of Article 14, which in effect will violate Article 13. So therefore, there cannot be any law which will violate the Article 13 of the Constitution. In the fundamental rights, more particularly Article 14, 16, 21, and all. Now, if the second aspect has not been done, as well as if the 13 of the rules have not been followed, can a person concerned become known as the application being rendered here? Because the basic idea why 166(3) was made in was only for the purpose of fixing a period within 6 months, because the legislature also knew that the moment there is a particular manner in which is given, an accident happens, there will be an R, then it will, there will be a, which will later on result into a DAR. And if no R, no DAR is being done by the statutory authorities, then 166(4) is also become there. Therefore, 159 is there. Let us see what is 159. The police officer shall, during the investigation, prepare an accident information report to facilitate the settlement of claim in such form and manner within 3 months, and containing such particulars, and submit the same to the claims tribunal and such other agency as may be prescribed. So here, there is a mandate given under 159. And if this 159 mandate is being given, then in that regard, and if you don't exercise that power under 159, and then to deprive somebody from the claim doesn't have.
What I want to point out is that that aspect is there, Rochelle. My aspect is that, actually, that while opting to file application of the section 116, there is a limitation. But in section 159, there is no limitation for the claimant.
No, not for the claimant.
Section for the police officer.
Because you have to further take note of, although all these amendments have been happening, but this is a benevolent legislation, which is for the welfare of the people. So under such circumstances, can you therefore say that whatever may be?
My point is that, my point is that once the AR is gave on a claim tribunal, that will be treated as claim application. But there is no bar to take up this, take that application, take that report, the claim application. Irrespective of the period.
So just for example, if the statutory authority who have been mandated by the legislature under 159, these are officers.
Yes, sir.
These are officers, it's a police officer.
Problem is that, my lord, these are not done properly.
Understood. Till it is not done properly, and these people will be deprived. Because the basic idea behind all this thing, in fact, yesterday's judgment of in the compensation amount deposited with motor accidents claim tribunal, you must have looked into yesterday's judgment of Justice Gopal, who is Justice Mian. They've given certain guidelines. Now, what is happening out here is the person who is actually entitled to is not getting the relief. Have you looked into it?
Sorry, yesterday. I don't have the copy right now, my lordship. But as far as this case is concerned, my lord, what I'm on the point, so the, once the claimant up to come under section of 166, this is as good as this is like a private case. Because other cases which are based on this report, there is no point of limitation. That is why, Lordship, I would like to place one judgment. When I think placing the judgment, Lordship, the Gohar judgment.
Gohar Mohammed.
Yes. The difference is made from that aspect, which I have been submitting Lordship. Lordship, you can see. You can see straight away paragraph 38. 38. Because the previous paragraph Lordship deal with the procedure by the police. Filing of car, FAR, paragraph 38. In addition to the said process of adjudication,
Where the accident took place?
Chief, the accident took place on 14/6/2022.
Where?
The Tezpur PS. The place name called, near, Gopultol Bazar.
Yes,
Tezpur.
two case. The FIR must have been filed there.
Yes, FIR was filed before the Tezpur case.
It's two PS. So how do you know?
It's there in the ten page. Lordship, may I kindly see, page number, 23 of the petition. Page number 20. Para 9.
Now, if you see Mohan Mohammad's judgment, more particularly paragraph onwards, because this was the specific submission in page, paragraph 51. I'll see.
In our
Yes. Amicus spirit, paragraph 50.
conference that execution duty claimants to file a claim under section 166. Occurred in a place where the accident has taken place. Taking reports of section 166 to BMD Amendment Act. The proceeding initiated under section 149 is required to be closed. To take those proceedings. It is also argued that the possibility of filing application by opting the claims tribunal at different places been categorized.
No, kindly come to this, paragraph 46. The claimants have been given three options to claim compensation before the claims tribunal. As discussed herein, the option under section 164 is without taking the proof of negligence, while option under 161 and 2 is by proving the negligence. In addition, section 149 is added, by which the de novo procedure has been prescribed immediate on registration of the FIR by taking action through the police officer before the claims tribunal. It is urged by the learned amicus theory that the said procedure is not being followed in most part of the country by the year. Now, because of that, the court gives directions at paragraph 47 and 48 to the police officer. Now, these are directions under 141. So these police officers have to are bound to follow this. Okay. So what I'm supposed to do, get hold of the permanent at 2. We'll take it up. Make that PS, the government and the PS a party. And then direct them to register what has happened, file the DAR and all these things, and then proceed. I think this appears to be the only problem, because there is already a direction without touching 165.
My prayer is that Lordship, this direction should be not only in respect of this two PS member, because the.
That is why I'm thinking of making the state of Assam a party. I'll make the state of Assam a party along with that. Get hold of Mr. Dipankar Nath. Okay? Now, this is an important issue. And these are directions which are given by the Supreme Court. And if they don't follow, that is why 166(3).
I may approach Lordship. Lordship would come to know, so if everything, there are 40.
You see, by now, Mr. Okay. There is another issue. Whether limitation act will apply to the tribunal?
As far as the language is there in section 163, because it starts, my humble understanding, it starts with the, oh, no.
No.
That
Don't worry with that, no. No is not there. We will not apply section 5. But what about the other provisions? Taking into account, I'm not saying about the Limitation Act. What about, just for example, it's closed? Then what happens? He is on vacation. What happens? How do you take care of the situation? Is it required? Then are you going to curb that period out? Now, the motor accidents tribunal is closed during the autumn vacation, which we have for a month or so. What happens then? Are you going to take away the 10 or 15 days out of it? Or the last day is tomorrow, but tomorrow is closed. Easter, bund. Oh, forget about bund. There's a bund. There's a curfew. You can't file. Then how do you take care of it? The legislature, see, all these, whatever may be, we may not set it aside, but what we can very well do is mold it with the exigency. Therefore, you have section 4 to 24 of the Limitation Act, which applies. Now, section 5 may not apply. Section 3 is okay. Section 3 prescribes the period. Now, if you see section 29(2), which says that if any special law prescribes a particular period, then which is different from what is given in the Limitation Act, then section 4 to 24 shall apply. But the question is whether the tribunal has the trappings of a court. This is another issue.
So, but section 116 of the previous section, there are some judgment that fabrics of the civil code is there.
So if that is the trappings of the civil court is there, then obviously section 5 will apply. This section 29(2) of the Limitation Act. Where any special law or local law prescribes for any suit, appeal, or application a period of limitation different from the period prescribed by the schedule, the provisions of section 3 shall apply, as if such period were the period prescribed by the schedule. And for the purpose of determining any period of limitation prescribed for any suit or hear by any special law, the provisions of section 4 to 24 inclusive shall apply only insofar as to the extent to which they are not expressly excluded by the special law. So there is no exclusion to that effect. Maybe section 5 may not apply. If we go by the interpretations given to section 34(3), or even the proviso to order 8 rule 1 given to the Commercial Courts Act, where it now fixes the written statement to be filed within 120 days, here also 90 days or 120 days, where there is a no. So there is an express prohibition of applying section 5. But then also the Supreme Court holds section 14 will apply, section 12 will apply. So these provisions duly apply. We were getting a certified copy of the award also. That award, if it is required to be certified, then that will also apply. So those provisions duly apply. So then in that case, something is burnt, something is wrong, then it will duly apply. 5 may not apply because of this. 5 may not apply because there is the word no. But I think we get hold of that and pass the talk. Better off for the time being, and then we take it up. Yes, Mr. D. Chakraborty, you seem to be very interested in the matter.
Brother also is taking this effect.
That is why I am not asking learned brother because he is always on this side. I am not on that. But you don't seem to be on this side. It may be under scrutiny where there might be a challenge to whatever may be. But the fact that Rohan Mohammed poses an obligation, is a direction. So if we can, without touching 166(3), we can very well pass an order to the referee, directing them to submit that and then to proceed. Because there's no period limitation for 166(4). So that can be a via media till the Supreme Court comes. But then also, tomorrow, At the end of the day, the Supreme Court comes up, oh, yes, 166(3), which I think they may also come up with the thing that Section 5 may not apply. Again, retrieve what is Goar moment to that effect and pass appropriate orders. Or may also say in view of the Salembar Association, if you remember that quotation whereby the Supreme Court categorically mentioned that you can't prevent the act of God. Big earthquake happens, then nobody gets anything. COVID or COVID, or let us take a case of a tsunami. It happens, person is not entitled to. So in those cases, something has to be given somewhere. We get hold of this way.
Yes. Yes. Yes.
Not see what is the case about out here with this. In 2019, there's an amendment to the Motor Vehicles Act. It was given effect from 1/4/2022. Now, under such circumstances, now the period of limitation has been put at 6 months for filing. But there is also a corresponding duty under section 159 upon the police officer before whom the FIR is being filed. To give there are three reports. First is the R, then iron, and then the DAR. When the DAR is being submitted, then the DAR automatically becomes a claim petition. That is the legislative mandate that the police officers will do their work properly. And this has also been further reinforced by the Supreme Court in Johar Mohammed, whereby there is a specific direction upon all police officers before whom the FIR is being filed to act in pursuance to that. Paragraph number 50, 48, 48, 49, 49. Give him Johar Mohammed. Police officers and the registering authority are duty bound to act as per the MB Act, and the rules are and submit the FAR, R, and DAR within the prescribed time limits as per the rules. The registering authority is also bound to take action in the matter of verification of the permits so and so, so and so. The insurance company is bound to appoint a nodal officer as per Rule 24 to facilitate the investigating officer in the matter of inquiry and investigating, submitting details regarding insurance and stakeholders. Now, if you see section 159, there is no period of limitation given, but there is a specific mention that within 3 months he has to submit the DAR from the date of the accident. And 173 charge sheet which is required to be given is to be given within 2 months as per the rules. Okay. Now, what has happened in the incident case? The accident happened on 27/2/2022. And this application was filed after 5 days after the completion of the 6 months. There was a section 5 application filed that was allowed, whatever may be. Then they filed another application that was rejected, for which they are before this court. But without touching 166(3), which we will consider later on, I think that we should make the state of Assam as a party, as well as also the officer in charge of testing police station in the party, so that appropriate directions can be given that so that they duly comply with. Now, if you see this particular judgment again out here at paragraph number 46. The claimant they've given three options to claim compensation before the claims tribunal. As discussed here in above, the option is under 164 is without proving the proof of negligence, while option under 166 1 and 2 by the claimant by proving the negligence of the offending. In addition, section 149 is added by which the de novo procedure has been prescribed immediate on registration of the FIR by taking action through the police officer before the claims tribunal. It is urged by the amicus curiae that the said procedure is not being followed throughout, and that is why the direction is being given under paragraph number 48 and 49. Let's see the third line in paragraph number 49. If the claimant has not opted for taking recourse under section 166(1) within the time limit of 6 months, such miscellaneous application may be treated as an application under section 166(4) of the MB Act and be adjudicated in accordance with law. Therefore, the procedure as per 49 is in addition to the proceeding of so and so, and such mandate is required to be followed in full spirit. So this is the basic idea. So therefore, we make this the state because this is required to be followed. This is a judgment of the Supreme Court. So it has required to be followed all over in Assam also. So we pick it up in this manner and so that this can be brought in all, it is being regulated and informed to all officials in that regard. Okay. Because there is another thing here also, if you see, if there is a claim petition filed and a DAR filed. Just for example, the accident happened at Dhemaji. Then the DAR is being filed by the Dhemaji police station. But the claims is filed out here in Guwahati. 166(1) is being filed in Guwahati. Then what happens? The DAR is being transferred out. This is as per government.
So for my knowledge, there is a notification from our High Court also.
No, this is pursuant to this. Because I was instrumental in making that MACT portal. So in that MACT portal, it has been categorically given how, what application, what is to be filed, what are the applications are required, everything is been. So this is what is there. So we make the state of Assam apart. And we show your appearance out there and put your name out there so that you appear. Okay.
I have asked them, because prior to this judgment, there are the other judgment, Procedural versus the Return of India, there is an order in the I, where some instructions have been given, and they just telephonically, they have informed that some instructions they have already issued to all the police stations. I'll place it.
No, it's
What's the-
okay. But
what's the-
not only that. In this case, if the DAR is being submitted, then the problem is being solved here. But this is required to be followed pan Assam everywhere, so that it is comes to a line with it is the mandate of the Act in the Supreme Court judgment. But Mr. the counsel appearing on behalf. None has appeared on behalf of the respondents in court. An important issue has arisen in the instant proceedings. In view of the amendment to section 166 by the Motor Vehicle Amendment Act 2022, whereby 19 Motor Vehicles Amendment Act 2019, whereby with effect from 1/4/2022, section 166(3) mandates that there can be no application filed in terms of section 166(1) and subsection 1 and subsection 2 of section 166 beyond 6 months from the date of the accident. This court also finds it very relevant to take note of section 149 as well as section 159 of the Motor Vehicles Act 1988, which post the amendment given effect from 1/4/2022. An obligation is cast upon the police officer before whom the FIR has been filed, as well as upon the registering authority to provide the verification for before whom the FIR has been filed for submitting the, what is the FIR means, first accident report.
It's there, so I have brought the rules 159.
What is FIR?
First accident report.
FIR, to submit the FIR, bracket, first accident report, bracket. Then comma, IR, IAR, interim accident report, as well as the DAR, detailed accident report, within the prescribed period as stipulated in the rules. It is also relevant to take note of the judgment of the Supreme Court in the case of Gohar Mohammed versus Uttar Pradesh State Transport, Road Transport Corporation and others, reported in 2023 46381, wherein a paragraph number '60 and 59, 60 and 61. The Supreme Court in uncategorical, in unambiguous terms have issued directions that the police officials, the registering authority, as well as the insurance company have to take due actions as stated therein. So the paragraph 59 to 61 to 62, paragraph 59 to 62 of the say judgment are reproduced herein under. In the present facts of the instant case, it is seen that the accident
That is 14/6
happened on, accident took place on 14/6/2022. And the claim application was filed on 27th of December 2022. And thereby there was a delay of 5 days beyond the period, 6 days beyond the period stipulated under
16 days.
16 days. Beyond the period stipulated under section 166 bracket 3 of the Motor Vehicles Act 1988. This course further takes note of section 166(4) of the Act of of the Motor Vehicles Act 1988, which further stipulates that in the circumstance, the claim application is not filed in terms with section 166(1). The DAR, that is the detailed accident report, shall be treated as a claim proceedings. In the instant case, it is not known as to whether the officer in charge of the Tesco police station before whom the FIR was filed, bearing FIR number, bearing police station case number, Tesco PS case number 828 of the 2022, have submitted the PAR, R, IAR, and DAR as is required under the rules. This court also cannot be unmindful of the fact that the Motor Vehicles Act 1988, providing compensation, is a benevolent legislation for the welfare, benevolent legislation. And as such, there is a requirement of giving a wide interpretation to the provisions of the said Act of 1988. Considering the above, this court deems it proper that the state of Assam, represented by the Secretary Home. Secretary Home will be number. The police Secretary Home, represented by the Secretary Home, having his office at Dispute, Guwahati, as well as the officer in charge, Dispute Police Station, be Dispute Police Station, Tejpur, be impleaded, arrayed as respondent number 5, 4, and 5 to the instant proceedings. Mr. Ibolita, the learned counsel appearing on behalf of the petitioner, is impleaded. Accordingly, the state of Assam, represented by the Secretary Home, should we make the commissioner and secretary also, because the registry and transport department?
Secretary is the highest officer.
No, not that. That is home. For the transport, commissioner and secretary transport, or additional chief secretary transport.
Additional secretary.
Transport. As number one, all personal commissioner and secretary, state of Assam represented by the commissioner and secretary, government of Assam, represented by the secretary, home.
Additional chief secretary.
Additional secretary, home, government of Assam, having his office at this school, Guwahati, 781006. Number 2, semicolon. The commissioner and additional secretary, chief secretary or commissioner? Additional chief secretary, transport department, government of Assam, having his office at the school, Guwahati, 781006. As well as the officer in charge of Tejpur Police Station, having at Tejpur, situated at Tejpur in the district of Sonipur, be arrayed as the respondent number 4, 5, and 6 to the instant proceedings. Accordingly, so and so are pleaded as so and so as respondent number 4, 5, and 6 to the instant proceedings. Mr. Dina, the learned senior government advocate, accepts notice on behalf of the newly completed respondent number 4, 5, and 6. And accepts notice. Extra copy of the instant petition be served upon him by tomorrow. This matter again on 13th of May. 13th of May 2025. Showing it as part of the newly imputed respondents shall apprise this court on the next day. The newly imputed respondent number 4 and 5 shall apprise this court on the next day as to what steps have been taken by the state of by the respective department, by their respective departments as regards the compliance to the provisions of section 149, 159, and 166(4) of the Motor Vehicles Act 1988. As well as the above quoted paragraphs of the judgment of the Supreme Court in the case of Gohar Mohammed Supra. The newly implemented respondent number 6 shall also apprise this court as to whether the PAR, IAR, as well as the DAR have been submitted in terms with as per the mandate of the rules, as per the mandate of the Motor Vehicle Act 1988 and the rules framed therein under. In respect to test group PS case number 828/2020. The interim order passed earlier shall continue with the next. Where the name of Mr. Dina, the registry shall reflect the name of Mr. Dina, the learned senior government advocate, appearing on behalf of the newly implemented respondent number 4, 5, 6. Because this needs to be channelized in Assam. Other places it has been done. Haryana and Punjab, I'm told they have already done it. Punjab, Haryana. Many places it has been done. Yes. Because there has to be, these people has to be informed. Now, I think the insurance company is aware about these things. The insurance companies are aware. But unless the first shooting doesn't happen through the FIR by the police officer to these 3 authorities, which is the claims tribunal, the owner, as well as them, in further proceedings cannot proceed. This is the problem.
There is another judgment from our High Court also that I will place.
Which one?
The ICICI number versus State of Assam. There is a WPC. In 2017,
What was that?
the direction was given to the police authorities to send the reports.
No, that was a direction, it was a mandamus. But now it is this mandamus, there is not only, has a statutory backing now. Apart from that, there is the direction under 141 by the Supreme Court.
Various steps have been taken. Various steps have been already taken.
So we take it up and once it is being filed, we make this proceedings okay. Because therefore, huh? Yes, what is this?
This is the landlord tenant matter. Tenant.
And then,
It is
when you are vacating,
no, I have a case this.
okay, tell me.
In regard to bona fide requirement, your lordship, the plaintiff had examined 2 witnesses. However, they were not incompetent, they were not competent witnesses.
Hmm.
As your lordship will find.
Has the plaintiff,
Plaintiff,
who is the tenant, with the landlord had examined himself.
Plaintiff, yes, yes,
Has he stated that he has bona fide requirement
yes, stated,
to cross-examine it?
clear process.
What does it have?
In the cross examination,
Does he say that he doesn't have bona fide requirement?
they have stated.
Hence, we don't
They have
require the other witness.
they have stated that there is a bona fide requirement. But that fee was that the inconvenience of the devotees. This what we call religious building. And the devotees, they
Oh, that Sikh temple.
Sikh temple.
Yes, they have a big problem. That is why on 17/3 I fixed it today for dismissal.
There has been a stay order that is also there has been a stay order. There is a stay order also that they have got with respect with regard to the execution. Because
Yeah. After this,
yes,
after 17/3. How?
there was actually the execution case, they received the notice. Immediately they filed an IA, and that IA and order has been passed, making the stay operative. Okay.
What is your case? Legal case. It is here. Tell me. Let us see the judgment. Is it a concurrent?
Concurrent, but in regard to the bona fide requirement, the trial court has said that the plaintiff could not prove the bona fide requirement. However, on appeal, the appellate court has reversed it.
And the other payment of rent defaulter?
That is concurrent, but both the courts below have only discussed about what is there in 5.4 without discussing as to what is there in 5.1 And the question is, when was the rent fell due? That was never decided by both the courts.
So you proved it.
Well, we have exhibited one rent receipt, which shows that the rent was paid for 5 months together. So by the conduct of the parties, I have annexed the rent receipt
There is
for
a
15
very
years.
beautiful phrase, Mr. Chakraborty. A beautiful observation by the Supreme Court in Maria. 2022, 5/6/20. Say, the right to, as you have continued earlier is one thing. But the right to continue in future is another thing.
But the back release that for 15 years.
So what?
We have been paying rent for sometimes for 4 months, sometimes for 5.
Very good. You have been paid in, yeah, but as per you, whether you are a monthly tenant or not.
No, we have stated that in our written statement, we have taken the plea that there was an oral agreement. However, they could not show anything. We have also stated that this oral agreement, they used to take the rent whenever they felt like. They used to come. I'll read the operating portion of the WS.
It's okay.
Then regarding that portion, the learned court below have not framed any issue also as to when the rent fell due. Both the courts have not decided that fact. Because it is a fact that for 3 months, sometimes for 4 months, sometimes for 5 months, we used to pay rent together. And the conduct of the parties shows that there was some laxity. And as per the oral agreement, it was a monthly tenancy. However, in the WS, we have specifically stated that the defendant begs to state that there is no written tenancy agreement relating to the suit premises, and there is no condition of paying rent on or before the first day of each succeeding. And at para,
Please see the record.
While I see the records, think how much time to take it. No, today. Today is the last day.
para 8 also of WS, the plaintiff did not take rent for the defendant. each month, but used to take rent for several months at a time for its own necessity and convenience.
Here, the issue number 3 is whether the defendant had defaulted in payment of rent to the plaintiff from February 2017 to 14 to June 2017. What is the issue number 3 decided? In which case in the defendant had defaulted in payment.
Page 42.
Are you saying that the rent when it fell due has not been decided?
First, your lordship, I have annexed the rent receipts here.
Forget about that. It has been clearly decided by the trial court. I've seen it.
One date which has been spindle of 8.
You have all your guns ready in the executing court? Go ahead. You dismiss his petition right now. Not entitled to even 6 months grace. Let me write down. Administrative Dr. Dalam. trial court judgment is good. The trial court judgment is good judgment.
For the IT requirement thing was concerned, that was not in my favor there.
Huh?
No IT requirement was not in my favor there. That was reversed in the,
You file an appeal,
so in fact,
you file a cross
they
appeal.
filed in the appellate judgment, the bona fide requirement that was held against the plaintiff. That has been reversed by ruling that by taking the vote of the prevailing law. Starting from Prativa Devi till Kanhaiya Lal, everything has been taken.
Heard Mr. S. Dr. the learned counsel appearing on behalf of the petitioner, Mr. D. Chakravarti, the learned counsel appears on behalf of the respondent. Petitioner or petitioners?
Petitioner.
Petitioner. The senator appears on behalf. The revisional jurisdiction of the court under section 115 of the Code of Civil Procedure 1908, for short the code, have been invoked to challenge the judgment and decree dated 31/7/2024, passed in title appeal number 12 of the 2023, whereby the appeal filed by the petitioner herein was dismissed, thereby affirming the judgment and decree passed by the learned trial court. Taking into account that the revisional jurisdiction of this court has been invoked, this court finds it relevant to take note of the parameters of the revisional jurisdiction within which the instant proceedings is required to be adjudicated. In the backdrop of the above, proposition of law, well settled, let this court take up as to whether the petitioner herein have been able to make out the case seeking to interfere with the impugned judgment and decree passed by the learned court of the Civil Judge Senior Division Lakhimpur at North Lakhimpur, hereinafter referred to as the learned First Appellate Court, entitled Appeal number 12 of the 2023. For ascertaining the said, for judging the said aspect, this court finds it relevant to take note of the brief facts which led to the filing of the instant proceedings. The respondent hearing, for the sake of convenience, the parties hearing are referred to in the same status as they stood before the learned trial court. The respondent hearing as plaintiff instituted a suit being titled suit number 18 of the 2017 before the court of the Munsif number 1 Lakhimpur at North Lakhimpur. The case of the plaintiff is that the plaintiff is a religious organization of Sikh people at North Lakhimpur. And is constituted mainly to propagate the Sikh faith through the Gurbani of the Holy Guru Granth Sahib. Holy Guru Granth Sahib to inverted commas. The plaintiff had let out a premises which have been specifically described in the schedule to the defendant at a monthly rent of rupees 3,000 per month only according to the English calendar month. Because earlier, the father of the defendant was the tenant of the plaintiff. And after his death, the defendant requested the plaintiff to let out the same premises to him in the year 1999. And since then, he had been occupying the said premises at a monthly rent of rupees 3,000. It was stated in the plaint that the rent was payable on or before the first day of each succeeding month. It is the further allegation in the plaint that the defendant willfully defaulted in payment of rent for the said premises for a period of 41 months. That is, from February 2014 to June 2017, bracket, both inclusive. It was also mentioned that the defendant, without approaching the plaintiff, have deposited rent before the court only since January 2017, which is not permissible in terms with Section 5(4) of the Assam Urban Area Rent Control Act 1972, bracket, for Act short, the Act of 1972. In addition to that, it is the further case of the plaintiff that the suit premises is the place of worship of the plaintiff community from plaintiff committee. It was further mentioned that the suit premises is located in a 4-story building belonging to the plaintiff. There is a hall in the 2nd floor with a worship prayer place. Bracket Darbar Hall. The 3rd floor is used for langar, bracket dining hall, and the 4th floor is used for kitchen and stores. It was also mentioned that there are various senior citizens who are of the plaintiff community who have difficulty in moving to the 3rd floor for offering their prayers. Under such circumstances, there was a decision taken that the Nisan Sahib be shifted to the ground floor of the temple, wherein the suit premises is situated. Taking into account that the rent was not paid for a period of 41 months and there was a bona fide requirement of the plaintiff of the suit premises, the plaintiff issued a notice dated 29/5/2017 asking the plaintiff defendant to vacate the suit premises. It was also a reply thereagainst was sent by the defendant stating inter alia that the defendant is carrying on business in the said suit premises. Situated thus, the plaintiff filed the suit seeking a decree for class possession of the suit premises as described in the schedule to the plain for a decree of rupees 1,23,000 being the area rent from 1/2/2014 to 36/2017, both inclusive at the rate of rupees 3,000 per month. A decree of rupees 300 per day as damages oblique mean profit, MESNE, and further damages oblique mean profit until possession is delivered to the plaintiff. Upon filing of the suit, the defendant filed his written statement wherein various pleas were taken, preliminary objections were taken as regards the maintainability of the suit. It was mentioned that the plaintiff did not take rent from the defendant each month, but used to take rent for several months at a time and for its own necessity and convenience. It was also stated that the plaintiff took rent for 5 months at a time from September 2013 to January 2014 from the defendants for its own convenience and issued the receipt. It was the defendant further stated in his written statement that the defendant paid rent up to the month of November 2016 and the plaintiff had stopped issuing receipt of rent without assigning any reason in spite of requests made by the defendant. It was also mentioned that the plaintiff had refused to take rent from the month of December 2016 without showing any reason in spite of requests made by the defendant, which made him to deposit the rent at rupees 3,000 in before the court from the month of December 2016 onwards. On the aspect of bona fide requirement, it was mentioned that the plaintiff is required to, that there was no necessity of shifting the Nissan Sahib to the ground floor. Instead, the plaintiff is required to provide electric lift and such like amenity in the multi-storied building. It was also mentioned that the plaintiff would use, that the plaintiff had let out room in the ground floor of the building, which is adjoining to the west side of the staircase recently. And the plaintiff could use that room or any of the 5 rooms let out to the tenants to be used as godown. But the plaintiff had targeted only the defendant without any just cause, and this is not possible. And it is not possible to shift the Nissan Sahib to the ground floor of the building. So, on the basis of the pleadings, The learned trial court framed 8 issues, which being relevant are reproduced herein under page 30 of the 1-2. On behalf of the plaintiff, two witnesses were examined and 2 documents were exhibited. On behalf of the defendant, 3 witnesses were examined and 2 documents were exhibited. The learned trial court, by their judgment and decree, dated 29, isn't it? 29/9/2023, had decreed the suit in favor of the plaintiff. In doing so, the learned trial court came to a categorical finding in respect to the issue number 2. That the plaintiff did not have a bona fide requirement of the suit premises. However, as regards the issue number 3, the learned trial court not only duly had taken note of the provisions of section 5(1)(e) of the Act of 1972, read with section 5(4) of the Act of the said Act, and came to a categorical finding that the plaintiff was a defaulter, a defendant was a defaulter in payment of rent. From February 2015 to May 2017. Also, on the basis of the findings arrived at in respect to the issue number 3, the learned trial court decreed the suit in favor of the plaintiff, thereby declaring that the plaintiff is entitled to recovery of past possession of the suit premises mentioned in the schedule by evicting the defendant, semicolon, that a plaintiff is entitled to get that area rent from 1/2/2015 to 31/5/2017 at the rate of rupees 3,000 per month, along with the cost of the suit, as well as being agreed, the defendant preferred an appeal under section 8 of the Act of 1972 before the learned first appellate court, which was registered and numbered as title appeal number 12 of the 2023. The learned first appellate court not only affirmed the decision of the learned trial court in respect to the issue number 3, but also interfered with the issue number 2 and thereby held that the plaintiff had bona fide requirement of the suit premises. On the basis thereof, the learned trial court, first appellate court, dismissed the appeal by the impugned judgment and decree dated 8th of August 2024. It is under such circumstances the present proceedings have been initiated before this court. Mr. F. Dr. the learned counsel appearing on behalf of the petitioner had submitted that the learned courts below failed to take note of Section 51E of the Act of 1972 in the proper perspective, inasmuch as the learned courts below did not decide as to when the rent was due. Full stop. This court have duly taken note of, we have duly perused the evidence on record, as well as the observations made by the learned trial court in respect to, as well as the observations made by the learned trial court in respect to the issue number 3, wherein the learned trial court had categorically dealt with the question as regards Section 51E, and more particularly as to when the rent fell due. And on the basis of the evidence on record, came to a categorical finding that the rent fell due at the end of the month. The learned first trial court as well as the learned first appellate court also categorically further dealt with that the plaintiff, the defendant has failed to prove that the defendant was not a defaulter in payment of rent. No perversity in this regard could also be shown on the evidence on record that the findings were arrived at in respect to the issue number 3 was erroneous or perverse. Full stop. And it was perverse, erroneous. This court further takes note of the decision of the learned first appellate court in respect to the issue number 2, wherein the learned first appellate court, on the basis of the evidence on record, came to a categorical finding that the plaintiff, the evidence had the bona fide requirement over the suit premises. It was further opined that it was not a mere desire of the plaintiff, but was a need, but was a bona fide need for the purpose of carrying out its activities. Considering the above, this court finds no ground to interfere with to exercise its revisional jurisdiction. Now, considering the above, this court does not find that there has been any jurisdictional error committed by the learned trial court or by the learned first appellate court in passing the impugned judgments. There is also no material irregularity or illegality in exercise of jurisdiction. Consequently, this court finds no ground for exercising the jurisdiction under Section 115 of the code, for which the instant petition stands dismissed with costs quantified at rupees 1 lakh. 1 lakh? 10,000. 11.
Stay in the.
NCR building.
Stay in the.
I in view of the dismissal of so and so, the interim order so passed in so and I stands closed. The interim order passed on so and so stands also vacated. LCR. Yes, what is this?
Application for amendment of plan was rejected, madam. One of the last occasion it had come up before your lordship. Lordship indicated that it was an
application, that's 2019. 2019. Why the amendment is 2024 when proposal has not been issued. So on a recall, the next one, order, Your Honor, page 42. What had happened in 2019, my lord? This suit was dismissed. Against that order, we came to the High Court. That is why so much of time was taken.
Huh?
2019, the suit itself was dismissed. Then COVID came up, we filed an application before the High Court, which was ultimately allowed, which is at page number 45. So that is why it took some time.
Then you filed section 80.
We filed it, we issued 80, and then it was restored, Your Honor. Then in 2023, we filed an application for amendment, which was eventually rejected in 24. That is why this application.
No, no.
My lord, let's see the
Section 80, this order was passed on 22.
22.
Then it was, section 80 was filed.
Filed.
Section 80 was allowed.
Allowed.
82 was allowed.
Yes.
Then without 82, then you proceeded.
We proceeded, and
Then
then we
what
filed that
happened?
amended application.
And what do you want now?
That amended application was rejected, my lord. My lord may come up to page.
What is the amendment you are seeking?
My lord, what had happened initially was being carried out by some other lawyer, but a lot of parties were made and a lot of release were claimed. We amended it, we made it shorten here. The absolute case was that the property belonged to my mother, and I got it by way of legal heredity. So we wanted to shorten out the pleadings. So we amended it. And at that point of time, my lord, the notices are also not issued. The other, that is the issue, my lord. My lord may come up to page 79.
Amendment notice has not, summons not issued.
Yes, ma'am. That was the issue, my lord. Harm is not issued, amendment may be allowed and notices may be issued. That was the only prayer. My lord may come to page 79.
Service done.
Service done.
What are phone numbers? 1, 2, and 3.
One, we have issued, taken Dusty, my lord.
Why only 3 parties?
Only 3, my lord.
You have reduced all the,
Okay.
so only 1, 2, and 3 is there.
Fine.
Then you filed an application.
My lord.
Where is the deputy commissioner? No government. But Mr. Akes, I have been in council. Supervisory jurisdiction of hope. Challenge the order dated 2024. Whereby the application seeking amendment was rejected. On the ground that if the proposed amendment is allowed, then it will create confusion in the long run and it will introduce multiplicity of the suits. It's also observed by the learned trial court that if the amendment is allowed, it would change the nature and character of the original. In as much as the plaintiff intended to introduce certain new facts from paragraph 13A to 13H of the claim, this court have duly perused the applications to file the claim in original, as well as the application for file seeking amendment of the claim. It is relevant to take note of that the suit is still at the state of summons. The defendants are yet to appear and file their written statement. Considering the above, it is the opinion that the learned trial court had exercised its jurisdiction, have not exercised its jurisdiction conferred upon it by law. In the manner and beside, conferred upon it in the manner and beside. In the manner and beside. Considering the above, this court interfered with the order dated 24/6/2024, passed in station number 302/347. Passed in Mise case number 16 of 2023, arising out of title suit number
74 of 19.
title suit number 74 of 2019. And allows the application have been registered as Mise case number 16 of 2023. The is directed to file their amended claim before the limit trial court on the date on May 9th of May 2025, failing which the consequences in terms of order 6/18 shall follow. The Berlin trial court shall thereafter proceed with the suit in accordance.
Fourteen.
Yes. Pass over one time.
Another
Okay. It's a matter of. The matter of first. It's a matter on 7th of May.
Fifteen.
Yes, what is this?
Here in this case, my lord, good proceeded as per the MIAN statement is not accepted, my lord.
Yes, we are paying for the respondent. Huh?
marketing in this case is the sizing model is the
Where is the imping order?
Improving order is a page 27, sorry, page 61.
Eight?
One second, 6-1. 6-1. 27, 9,
6/1.
6-1.
My question is that
The same council who appeared as the receipt, the same council.
Huh?
The same council receipt who appeared in the title suit for the defendant receipt, they appear from the first day, without the file number receipt. They appearing from the first day, this will kindly come to page 53 receipt and is the 9. The petition, they filed under order 9. There are no mention about what is the case.
See the page 43. 43. There is no wakalatnama. Then how can a person appeal?
They are appearing from the first day, every order it was mentioned also that they are appearing.
Who is the lawyer who was appearing? Who was the lawyer who was appearing?
The name was mentioned.
under the order six, I have. You are looking at the service report is awaited, my lord, and the affidavit that we are shown is that only in the respect of active mistakes, my lord, which was already dismissed, my lord. And that part is also admitted in their affidavit. And your lordship also verified it. Thank you.
It's the same, it was appearing from the first day, he filed the expertise.
That may be without.
Petition.
How can counsel will appear, my lord? That was denied by the defendant, at page 50. my lord.
Finally, come to page 39, 40. Both sides are represented, plaintiff is yet to take steps. Steps for what?
Fair is allowed both substandard on that.
How many defendants are there?
Five.
So then why the court is fixing for steps?
Yes.
It appears to be wrong.
Yes. Yes. That defendant appearing from the first day, but without any equality.
See, on 22/3/2023,
Yes.
the result of the case record reveals the defendant has been filing Hadira since 5/1/2022 without any wakalatnama and written statement which is not tenable in law. However, for the end, the last chance is given. Now, whether this actually it was happened, who was the advocate who was appearing? The court should have been more strict. Huh?
Concept of the petition, they filed lawsuit for page 52. And we can,
And the court also does not mention. Hello. Interfere. Take the written statement. See the I was the the learned counsel appearing on behalf. Who also appears on behalf of the respond numbers.
Only one respondent, my lord.
Sorry, on behalf of the respondent. Full respondent. Respondent number one, who is the plaintiff. The petitioner herein have challenged the order dated 27/9/2024. The supervisory jurisdiction of this court has been invoked by the petitioner challenging the order dated 27/9/2024. Passed in the case number 230/2023, whereby the learned trial court have rejected the application under order 9/7 of the code. As well as has also and as well as did not accept the written statement so filed by the petitioner before the learned trial court. This court have duly perused the materials and record, including the orders dated orders till 26/2023. Orders passed in the title suit till 26/2023. Wherein it is apparent, wherefrom it is apparent that some person was representing the defendant without any wakalatnama. The learned trial court is further relevant to take note of the manner in which the learned trial court have also proceeded in the suit. In as much as, on one hand, it has been mentioned that both the parties are represented, and on the other hand, had fixed the matter for SR and WS, which clearly shows the complete non-application of mine. Even in the order dated 26/2023, by which the learned trial court have proceeded ex parte against the petitioner, there is a clear mention that no wakalatnama has been filed by the counsel who was representing the defendants. It is the specific case of the defendants that they had no knowledge about the suit. And it was only on, when did you come?
Under question.
Huh? And it was only on 19/7, nah? 19/7/2023, the defendants came to know about the pendency of the said suit. And accordingly, the defendants thereupon filed an application. The petitioners thereupon filed an application under Order 9/7, read which section? Order 9/7, for setting aside the ex parte order dated 26/2023, and further to accept the written statement. This application was rejected by the learned trial court by the impugned order dated 27/9/2024. It is also relevant to take note of that in the meantime, the plaintiff, the petitioners had also submitted the written statement on when
12th of July 2000.
12th of July 2023. On 19th of July 2023. 19th of July 2023. Even prior to filing of the application, and seeking vacation of the seeking filing of the application under Order 9/7 of the court. It is well settled that the rules of procedure are intended to be handmade to the administration of justice. A party cannot be refused just relief merely because of some mistake, negligence, inadvertence, or even infraction of the rules of procedure. The court the court always gives relief. In the backdrop of the above materials, from the court is seen that the learned trial court not only proceeded with the suit on an assumption that the defendant numbers, the petitioners were duly represented by a counsel. The learned trial court have proceeded with the suit on one hand, assuming that the defendant numbers 1 to 5 have been duly served the notice summons, and on the other hand, the summons on the basis that the defendant numbers 1 to 5 were represented by some counsel, and on the other hand, the plaintiff, the learned trial court also was clearly aware of the fact that the defendants numbers 1 to 5 were represented by a person who did not have the power to represent the defendant number 1 to 5. This court further takes note of that the defendant immediately upon coming to learn had filed their written statement before the learned trial court. And the learned trial court ought to have allowed the said, accepted the written statement and proceed with the suit instead of delaying the disposal, instead of rejecting the application under Order 9 Rule 7 by the impugned order. This court further finds it very appalling to take note of that the application was filed on 9/8/2023 before the learned trial court, and it had taken more than a year for disposal of an application seeking vacation of an ex parte order and for acceptance of the written statement. In this process, a period of more than a year had passed by, which, in the opinion of this court, was not in the interest of justice. Accordingly, this court interfered with the order dated 7/9/2024, passed by the learned trial court in midday case number 230 of the 2023, and thereby it directs the learned trial court नाम तो कुछ नहीं civil was number अच्छा नाम trial court to accept the written statement filed by the defendants, the petitioners, the defendants number 1 to 5 in the suit, and proceed with the suit in accordance with law. With the above, the listed proceedings stands allowed.
Item 16.
Wait, please, madam. This is second FT, it has come for the first time. Against complaint five. My case was simple, but I filed a suit for declaration of right title interest, cancellation of the gift deed, and permanent. My suit was thereafter my on 19th, it was also dismissed. My case was that my lord, I had never gifted the gift land to the respondent number 1. The respondent number 1 is my
If deed is by registered gift deed. Hindu? So you have challenged the registration. And what is happening?
My case was that I had gifted the gift land to the daughter of the respondent number 1, who is my granddaughter, and not to the respondent number 1. And as she was minor at that point of time, so the respondent number 1, they would come as a representative capacity, not as a full. That statement was in fact accepted also in the written statement as well as in the evidence. But that was not considered.
But once you have gifted, what right do you have?
But I had gifted, But to my granddaughter, not to,
So what? The granddaughter should come. Who are you?
but because it is my property,
Once you have gifted, you have given up your rights.
right? If it was a valid gift, if my then it's not a different thing.
If the gift is not invalid, prove your by self your say that you have executed the deed of gift, but in the name of your granddaughter. And thereupon, and wherein the respondent number one was made the caretaker or whatever. Till she attains the majority. Okay, so you have your gift is complete.
But the thing is that madam, I had gifted the property as a love and affection, so the income that is derived from the gifted property that can be utilized for further education of the daughter of the respondent number one. Now, madam, my respondent number one, she has already divorced my son. The question of love and affection towards her, that is suddenly because I have no love and affection towards her.
But your gift deed is not wrong.
If it is wrong only in respect of my donate, except
No, you never know tomorrow. Once you have already gifted out of love and affection, you had the love and affection then.
only condition my lord that was gifted was
There is no
because,
condition in gift.
my lord,
Can there be a conditional gift?
my lord, what I meant to say is that my lord, the conditions that was required for execution of the gift was there, the name of the respondent of the one daughter has to be there. That was not there. So the condition was not good as to who would be the donee. The name of the donee was my lord misrepresented, and under fraud, my lord, it was
No, this is subsequent.
subsequent.
But the deed is okay.
It is otherwise okay, my lord.
Deed is okay. It's not otherwise. Deed is okay. Once the deed is okay, what right do you have? The donee, the daughter, granddaughter can very well come over and say that, look here, I have the right, not the respond number one. Who are you?
I'm the donor, my lord.
So you have donated, matter over,
I donor my property.
transferred. Transferred.
Transfer, my lord, not to the person who
You,
appears in the.
no, your gift deed is okay.
But as per me, madam, the gift is not okay because the donie's name is.
What?
The donie's name that has been madam misrepresented. That is why it is not okay.
No. And who is the donee?
Madam, donor is madam myself, the plaintiff. Donee is madam, it had to be madam, the
No, you
granddaughter.
know how to study English.
Madam, there it is written that I am very educated man, woman, madam. But as per my petition, I have only passed class 10 and I'm not well attended.
Past.
Class 10 good at home.
And gift was in Assamese English. So you didn't know.
The name was appearing, so I thought maybe pilot the name appears on the representative capacity.
Then,
And plus pilot, another point is that pilot,
so once there's a divorce, then you knew what is the gift.
after divorce, in fact, in the joint compromise petition that was filed in the divorce proceeding pilot, this was one of the criteria.
Today I have already discussed so many matters.
And pilot plus section 68 of the evidence act was also not that criteria.
You have no business out there. You are challenging, and when was the gift executed?
Pilot, it was executed,
In 2009. When did you file the suit?
it was filed in the.
Huh?
It was filed, my lord, 2009.
2009 itself. What is your allegation?
Allegation that my lord, what was paid, it was misrepresentation on the part of the respondent number one.
Friend number one,
Second,
you gifted the heir to whom?
the daughter of the who is my granddaughter,
Friend number one now has divorced me.
the pro forma dependent number two.
Huh?
Pro forma dependent number two is my son. The present respondent number two,
Who is the
Pranab Jupiter,
former defendant number two is Umesh Chandra Das.
my lord, Pranab Jupiter,
The defendant number three,
dependent number two, the respondent number two.
the former defendant number three.
Umesh Das is not,
He was married to Manjula Das. And who were the signatories?
One of the signatory was my son.
Then what does he say? He doesn't know how to read. He read English.
The thing is that my mother, she divorced him because he was an alcoholic.
Huh?
He was an alcoholic.
Who?
Manjula Das divorced my son because my son was an alcoholic.
Very well.
Most of the time, my dad, he was intoxicated.
Yeah.
So whether he could understand the contents of the deed, that is my dad. What it-
Right, yeah.
And-
And you raised all these issues before the trial court. And what happened? Did this person say Pranab Das say?
That's not a thing. And
He did not. Then did you prove that he was intoxicated?
that was accepted by the, in fact, that was the pleaded case of the dependent number one.
That
That he was an alcoholic and that,
maybe, but was he alcoholic then?
that he was
Did you prove
not
that?
alcoholic.
Okay. Plaintiff herself, PW1 and relied upon. How many PW?
He had examined 3 people.
Certified copy of the order and decree divorce. Because of the divorce, all these things happen.
Right.
Decree of divorce was in 2002. And you executed the gift deed in 2009. Then
In the joint petition that was filed in the divorce matter, it was specifically stipulated in one of the clause number 9, that I, that is the plaintiff, would hand over the second floor of the property to the granddaughter, to my granddaughter. That was one of the stipulations. And as per that stipulation, the deed was executed. Subsequently.
so you have no business out there. Now you see a affidavit of the claimant, page 17. There is no mention that these statements made in the paragraphs of the plaint have been explained to you and made for you to understand. So you can understand the states, contents of the plaint, but you don't know what is written in the gift deed.
Communicated with my lawyer,
No, you can't do that. There also, it's the same thing there.
but respect of the deed, that is completely different. Plaint is completely different.
And the son was, and the son in 2009, when the gift deed was executed, he was the witness.
But my lord, he was not got into the evidence part. He was not examined as an evidence by the.
Why will he be examined? It is for you,
Because they have to under section 68 of the evidence.
then a gift deed is to be examined.
Attesting with
Is it required? For gift deed,
the-
let's see,
I have a judgment also, my lord. High court as well as.
judgment is later on. Judgment later. What about the proviso? Section 68?
Provided that it shall not be necessary to call an attesting witness in proof of execution of any document, not being a will, which has been registered in accordance with the provisions of Indian Registration Act 1908, unless its execution by the person whom the purpose to have been executed is specifically denied.
You are not denying.
But look, I have denied that,
You have not denied. You have executed.
but the execution part, madam, because the contents of
No,
it
this
was
type
not
of
ready
case
to-
doesn't count.
contents of the keeping was not ready.
No, don't come up with it. Now you wanted a dismissal, you have asked you not to go further, but you have now. So we dismiss your appeal right now. You want the dismissal to be on the same day with your senior dismissal, which is fixed. Same day together, we get your dismissal along with your senior. When did I fix it yesterday, the other matter? Six,
6-5.
6-5 together. 6-5 both. Your matter and senior. First your senior dismissal, then not. Mr. A, well, the learned counsel, I passed the same type of order also. Mr. A, well, the learned counsel appearing on behalf of submits that he would like to further. It requires 2 weeks' time to assert as to whether there is any substantial, any substantial question of law that can be proposed in the instance. It's the matter of. Up to 7-5.
Place.
17.
No? Time being, no time being business. What is it? You are? Insurance? You paid the money? Huh? You are claiming? Ne? Hello. You are for insurance. One number 4. Injury case? Injury case? Owner. Who is the claimant? Claimant is number 1.
Payment already notices served.
Huh?
Payment notices has been served also.
What?
As per office dated 35/24. It has been served on the.
The matter has come up for the first time we wrote this food today.
Oh, lordship.
It is only for a delay. Delay is disposed.
It has come from
It's the matter of 2 weeks, the request to the union council for that.
18 and 19. Whether for admission, madam. It was delay was on the practice on the court. So this for admission of the.
How much?
Delay is already got up by.
How much amount?
Is it that case?
Huh?
Yes.
Hello, pay the 18 lakh. Pay the 18 lakh.
And in the case that
Huh?
payment is the owner of the vehicle. And this is the wife of the claimant. But in nature also listed for this also one way.
This is the wife of the claimant.
And the vehicle was given by his brother of the claimant, one brother, one claimant,
Vehicle was?
given by the brother of the claimant.
To whom?
At the time of relevant time of accident, the vehicle was owner of the vehicle is the claimant number 1. Wife of this is the
claimant number, this is the wife of the claimant number one. And the rider is the brother of the claimant.
An appeal under section 173 of the Code of Civil Procedure 1956. Challenging the judgment and decree judgment and award dated 5/2016, passing MSC case number 272/2012, whereby an amount of rupees 18,95,056, along with interest at the rate of 9% per annum, was awarded by the learned court of the learned member of accidents claims tribunal, Silchar. The appeal is that Mr. Archipel, the appeal counsel appearing on behalf of the appellant submits to the ground of objection taken in the memo of appeal is that the claimant number one is the husband of the deceased. The claimant number one was the owner of the offending vehicle, and he was the husband of the deceased, and the driver and the one who was driving the vehicle was the brother of the
Claimant number one.
of the claimant number one. He therefore submitted the question of he therefore submitted that the claimant number one and he therefore submitted that there was no involvement of any third party, for which the question of awarding the compensation of rupees 18,95,056 along with the interest arises, which is an error apparent on the face of the record. So, taking into account the above, the appeal is admitted for the courts. I civil from the conclusion application filed under order 41 rule 5 of the Code of Civil Procedure 1908.
Item number 117.
1172. Application under order 41 rule 5 of the Code of Civil Procedure for stay of the judgment and award dated 3/5/2016, passed in MSC case number 272 of 2012. Whereby an amount of rupees 18,95,056, along with interest at the rate of 9% per annum, was awarded on the date of filing of the claim petition. To notice making it returnable, about the committee steps upon the respondent by registered as well as you. Call for the record to receive. Should notice upon the respondent numbers 1A, 1B, 1C. Who is two?
Is the again,
Owner.
come back here, claimant.
1A is two. 1A is two.
One name. The same person, the owner, because the owner is.
1A, 1B, 1C,
They are the minor file.
and
See the one,
it's okay. 1A, 1B, 1C. They were minor then. 1A, 1B, 1C, and T. Was take by registered as well as usual within 3 days. Because there is no requirement of issuing notice upon the respondent number 2 in as much as the respondent number 2 and the respondent number 1A is one and the same. Because taking into account the grounds taken in the memo of appeal and the fact that the memo of appeal has been admitted,
This court states the improved judgment and award dated 5/4/2016 passed in MAC case number 272/2012 by the learned member Motor Accidents Claims Tribunal, Silchar at Kachar in the next state. Is the matter of which should notice making it returnable on behalf of liberty. 28th of May 2022.
20.
Lordship, this MSc appeal is pertaining to compensation family pension in lieu of compensation.
Huh?
This MSc appeal is pertaining to compensation family pension in lieu of compensation appointment. Lordship, there is no loss of dependency since the family of the deceased is already getting the last round salary. The deceased. That is our content.
That's true. So what is required? There are two judgments of the Supreme Court. One is Shashi Sharma and the other one is Birender. Birender says that if that application is allowed, then the amount becomes payable towards financial assistance under the state rules to be specified. Legal representatives of the deceased commensurate amount will have to be deducted from the compensation amount along with the interest component thereon. And the response number 1 and 2 therefore can be permitted to withdraw the compensation amount only upon filing an affidavit cum declaration before the executing court that they have not received nor could claim any amount towards financial assistance under the rules. And if already received or to be received in future on that account, the amounts for received will be disclosed to the executing court, which will have to be deducted from the compensation amount determined in terms of the order. Now, in view of this, can't we dispose it of? Saying that, okay, amount is okay, go there. And then they will deduct this.
Yes, Lord, they can be remanded back to the tribunal.
No. Amount which is there is okay. But the learned executing court at that point of time shall insist on this. See, a recent judgment of the Supreme Court has come also on 2025 SCC online SC 755. It is similar to the case of Haryana assistance in a person died in harness. Then what is given is that person, the amount which is done is that per Solar Burma Pranay Sethi amount is being done. After doing it, this amount of here in the case of 70 lakhs is there. They will go. So they have to give an undertaking that they have not taken any benefit under that notification. And if they take any benefit under that notification, in that regard, that amount which is there, the executive court will deduct while making the payment.
Yes, sir. Thank you.
It seems to be the proper way. We do it, because admitting all these things makes no sense. Because this, the trial court should have looked into it.
Yes.
Didn't it? You have a look at this judgment. Okay, take it up. After New India Assurance Company Limited versus Sunita Sharma, reported in 2025 SCC online SC 755. Okay, we have a look at it. And more particularly the judgment in the case of Virendra, which have been referred to, is very important out there. This is for the executing court. So we can pass an order without interfering. But in view of the law laid down by the Supreme Court, they will get whatever it is, but either they have to say that we are not taking anything from them, and if they take, then whatever is to be deducted for at the time of payment.
Yes, that will be better.
And that would be also not accruing of interest also for you. You will deposit, because your only issue is that.
Yes.
Isn't it? So then that amount gets deducted. Have a look at it. Okay, and the other judgment is 2020 SCC online SC 28. Okay.
Yes.
This the matter again. Fine.
Awesome. 21.
Yes, what is this?
Appeal is against the judgment caused by the runner.
Asking for enhancement. You are for whom? Oriental.
On the ground is that lordship, the claimant who has been lordship stated that her husband died in the said accident. The lordship, as per information of the present appellant, the fake lordship information, they have manipulated some documents, filed this claim petition.
Huh?
Prior to filing this claim petition lordship, another person who claimed to be the driver of the vehicle filed a claim petition, and that has been already judgment was delivered. We have satisfied the over. Subsequently, it has come to the knowledge of this appellant that already we have already satisfied the over. How this two person can be driver of the vehicle. So
He's
now-
also driver
Yes, she has also stated that her husband was dead in this case
of the same vehicle.
of the same thing. Now, lordship, I have.
And how does the trial court look into it?
Tribunal lordship, on the lessons on the part of the appellant,
The deceased died. For the opposite, the deceased was not the driver, yes, so the question of the death of the deceased does not arise. It appears from the record that one Shiva is the owner of the vehicle, so he would have been the best witness to make clarify the matter, but Shiva did not appear in the case law. And number two, took any steps to examine the safe people. So the plea of the learned advocate is a mere plea and it is not due to email. Now, in respect to the same incident, the same accident, Shyam Lama, who was the driver of the vehicle, died. Here that the accident took place on Nilan Ramdam came under Vipa police. The same accident was the driver of the vehicle. Here, what is the name of the driver? Shyam Lama.
husband of the claimant is Shyam Lama.
Shyam Lama.
And the case was the other person filed by the one Raju Tamu.
Huh?
One Raju Tamu. who is
And
alleging the
where is that aspect
That aspect-
taken note of?
The judgment of that has not been reflected. But I
Then
have taken the
it must be mentioned in your written statement.
person after filing subsequent, after filing written statement, it has come to an observation. But
Huh?
after filing written statement, lordship, they have come to know that two proceedings are there.
No, I am saying, did you mention in your written statement?
Not there.
You have not. Then how can you raise this issue here?
Because lordship, after coming to know about these two cases, this petition, this applicant lordship filed an
When
application.
did you come to know?
Lordship,
You cannot raise all these things for the first time here.
no, lordship, first time, not the first time. I have received all orders of the trial court. Just on 13/8/2024, this Appellant was raised and accordingly.
No, Mr. Kulitra, the question is, first of all, you cannot raise all these issues unless these are issues before the learned trial court.
Direct trial court also before trial court.
You did not raise anything.
was raised also.
Then where,
And after also raising this issue. the
how
learned
did you
trial
raise that?
After raising the issue, the learned trial court called for the LCR of all those cases, 3 cases, Lordship. Yes, I have received the details of learned trial court. And in learned trial court, Lordship, I will bring on record as additional evidence. On 13/8/2024, learned trial court has called for the LCR of all those 3 cases. And but Lordship, it is that immediately after 10 days of calling those records, the learned trial court has passed this judgment without Lordship mentioning a single Lordship word about this TR code. It is record mentioned Lordship in the order.
So you must have filed a petition for calling those
Yes,
records.
Lordship, petition was filed. Accordingly, this record was called.
So why haven't you taken that thing in your written statement?
Written statement was after, yes, they could have Lordship filed additional written statement, but that was
Why?
to Lordship, bring all this facts. Regarding this NSA.
How do I help you?
Lordship, at this stage, Lordship may, give me some time so that I can Lordship bring on record everything like the judgment of 3 cases.
You do one thing. You file an application under order 41, June 27, okay? Along with the judgment of that, okay? Being on record that, and then we may admit. Otherwise, I'm not going to admit.
I'm also, it's up to my client because it's certified.
And how much?
2 weeks.
2 weeks, leave the matter,
Because it can be changed, Lordship, because the certified.
make it 6 weeks.
6 weeks.
I won't be there.
6 weeks.
Leave the matter on at the request of Mr. Jacob. Let the matter be listed on 16th of July in order to file an application under order 21, 41, and 27. 22. What is this? Enhancement? Why?
It's a lawsuit. The deceased was a businessman lawsuit we were doing. He was doing lawsuit Procedural.
Huh?
Income of the deceased was lawsuit 10,000. But 6,500
What did you prove?
But grocery shop is concerned lawsuit, but nothing was to prove.
Because you don't prove it to prove something. What were you doing there?
But that was a lawsuit against evidence that he was doing a grocery shop. That was not regulated by the.
No, nothing there. No case.
But then secondary lawsuit, the interest lawsuit, that has been given lawsuit only from the date of evidence.
Obviously, you were delaying it.
But the date of incident that was taken place on lawsuit 19/7/22. And to file this claim petition on 5/8/22. WS filed out in the year 2023. The 2024 lawsuit evidence file. From the date of evidence, the lawsuit that has been made. The lawsuit time.
Interest when?
Case 23 lawsuit. Last. 2 lines lawsuit, 3 lines. There is no explanation as to why the interest has not been paid from the date of filing this claim petition.
Which New India? Who is New India? Anybody from New India? Anybody? New India? Okay. We appear in this matter. It is unnecessary that appeal otherwise is to be dismissed. But only thing is that the interest should be given from the date on which the application was filed. Filed was in 2022. Judgment was passed in 2020. So, MSc case was filed in 2022. Judgment was passed in 2025. There is no reason, only that. Otherwise, remains the same 5,85,000. Nothing various to other case. To appear. Take me, give him a copy. He will appear. We'll finish it up. Next. It's a matter we listed on 7th of May, we get your instruction, give him up. We finish it up. You will only get 6% from the date of filing, nothing more expensive. 23. Indian National, all Mr. KK Bhutto. Yes, what is this? What is the ground?
Vehicle involved in this case was a ultra bus.
Huh?
People involved in the accident was a ultra bus. Did not have a parking. Good parking.
The pain recover.
Okay. And it has been quantum also we have taken.
Why?
Monthly income of considered as this 9,000. There is no proof of income also. It may be admitted, related to WJP, person.
10,000. So without income, without anything, you put 4,500, 6,500. What is the rate?
7,000. 7,000.
Not 7,000, 8,000. The 7,000 was long time back. What is the? Huh? Hello. Total is how much? 16,25,000. Interest given. Interest? 6%. You, I'll admit the appeal. Admit the appeal. Pay that amount along with interest deposit. 75% along with interest. How much it is? If I pass the order, you see, calculate how much it is. 16,25,000, how much? 26,500. Take out 75%. Mobile, calculate. Calculate, and by the time I finish up that order. 75% of 16,26,500. Of which the PK Bhutto, the new council is paying on behalf of the applicant. Appeal under section 173 of the Motor Vehicles Act. Challenging the judgment and award dated 5/2/2002, asking investigate 2022 by the accident came back. Magic. The PK Bhutto, the new council is hearing on behalf of the appellant submitted that the learned tribunal have submitted that there are two primary grounds of objection against the impugned judgment and award. This is first, that the offending vehicle did not have the permit and resultantly it violated the terms of the insurance for which the amount for which the learned tribunal ought not to have settled the liability of the appellant. Secondly, it submitted that there was no proof of any income produced before the learned tribunal. However, on conjectures and surmises, the learned tribunal had arrived at the monthly income to be 3,000. We submitted that in normal circumstances, taking into account the price index, the price could
the monthly income could not have been more than 7,500. Which, taking into account the state grounds of objection, the instant appeal is admitted. Also, record steps be taken on the respondent by witnessing that the inclusion. I agree with that. This is an application file. And the order 41 will file for challenging the possible stay of the judgment and award dated 5/2/2025 passed in MAC case number 06/2022 by the Court of the Motor Accidents Claims Tribunal, Himad Puspa. This court have in the that have already admitted that the company appeal and is of the opinion that the informed judgment and award is required to stay. However, subject to payment of the fees.
On the interest, what's it comes,
No, not along with interest. Payment of the fees. Along with interest, how much? 75%?
13,76,270
How do you say so? From the date of filing of the claim petition.
for 3 years.
You don't take up like that. But how much it is the exact amount?
So 11,37,500.
11 lakhs,
37,500.
500, and not with interest. At the rate of 6% from the date of filing of the claim petition. Deposited before the registry of this court within 6 weeks from today. After the hearing of the registry, the respondent will be admitted to the high discussion. 24, I line making with it. It is observed that in the circumstance, there is a violation to the terms of the insurance, this court to pass appropriate orders for recovery of the said amount by the applicant insurance company from the owner of the vehicle. Really?
Yes. But then there's an appeal on the quantum of compensation.
The ground-
Driving license. And also wheelchair.
Eh?
Also wheelchair. This appeal is against three findings. So on the income, wheelchair person and driving.
It's a prospect and data.
No, wheelchair person, again, it should have been 25% just taken as 30. Not saying wheelchair person not age. Wheelchair person should have been considering his age. Should have taken as 25%, it was considered as 30%. Income has been considered as 20,000 per month.
Without any.
We don't have. This company, on the other hand, had examined witness who said that he was working as a daily wage.
Daily wage.
They said that they are the hotel, roadside eatery. But then he said on inquiry, he came before the tribunal.
The future prospect was also good.
Before his death, he was working.
So there, your ground is first is on the quantum, on the ground that the income was, monthly income was wrongly computed. Number, without any evidence. Number two is, regarding
Wheelchair person just
future prospect
taken as 25% instead,
at a higher side,
30% instead of 25%.
30% instead. And then number three,
That this company has given evidence. But, very interestingly, even the owner and driver, they filed written statement without mentioning their driving license number. It's nowhere, neither in the MBR report, nor CISA list, nor the driving license number. It will check it could not have been any driving.
they
They filed the
didn't,
written statement, they give the policy number and no driving license. Just similar to the case of Papu versus Vinod. There's no mention of driving. Just the policy.
so you have taken the plea.
Yeah, we taken the plea that
There was no driving license.
driver did not drive, did not have a driving license. And also in.
And it was the duty of the owner also. Then
Say that also, plead those foundational facts.
and also prove them. You mean that pleading the counsel would have shifted the owners to the owner?
So how much is being given? 27,
27.
pay 50%. 50%. And then recover that thing. itu ini लिखी थी खाली मैं माधव कथा which are Swami the learned council appearing on behalf of the and submitted that there are primarily there are three grounds of objection on the basis which the present appeals has been filed. First, the in spite of the pleadings taken in the written statement that the driver of the vehicle, offending vehicle, did not have a driving license. The learned tribunal settled the liability upon the appellant insurance company without ascertaining as to whether the driver of the offending vehicle had a driving license. Secondly, the manner in which the monthly income was adjudged by the learned tribunal was erroneous in as much as without being any proof, without providing any proof of the income. The learned tribunal could not have arrived at rupees 20,000 as the monthly income. Thirdly, the future prospect which have been the amount granted to the appellants to the claimants on the ground of future prospect was also on a higher side in terms with the judgment of the Supreme Court in the case of Procedural. It says National Insurance Company versus Tenancy reported insurance wherein the claimants would have been at best entitled to 25% and not 30%. It is down to refund stayed subject to deposit of 50% of them with interest. The interest is 6, na? Interest given is 6.
Next question. 35.
Yes, what is this? Enhancement.
Our case has been dismissed.
Very good.
And that too without any reason.
Why dismissed?
So I am the Indian driver. The accident. There is only involvement of one vehicle, that too. No merit has been decided that based on a.
Delay? On the ground of delay.
No, it's not on the ground of delay. It's a very peculiar pattern. Lordship, I kindly say, page 25 of the judgment.
Huh?
Where they have stated that an order has been passed by this honorable High Court in another case, which is no way connected with the metrics of this case, where it has been stated that the director, it has been direction that has been given by the High Court that to the DCP, that instruction needs to be given to every police station that only after registering a case, an affair, after registration of case, that form number 54 has to be issued. In our case, your motion, our case hasn't, there's no, unfortunately, unfortunately, whatever, our GPNC hasn't been translated to the at police case. But in other aspects, starting from the rational evidence, we have proved the case, everything. But the court, instead of going to the middle of the case, simply based on this judgment, which is no way connected to the metrics of this case, has decided the case as non-maintainable, which is in fact is not also made a issue there. Beneath of the case has not been decided.
Okay. You can appeal under section 173 of the Motor Vehicles Act, challenging the judgment and order dated 4/1/2025 passed by the member
Learned member, Motor Accidents Claims Tribunal, number 3, Kamrup Metro at Guwahati, in MSC case number 429/2019, whereby the claim proceedings have been dismissed by the learned tribunal with the, on the ground that there was no, on the ground that there was no GD entry,
There's a GD entry, but there was no case registered.
there was no case registered. There was no case registered. Although there was a GD entry. Which, taking into account the grounds of objection taken, the approach steps to be taken.
They mentioned and lordship, the execution is going on. Next date is of 13/5.
Huh?
Preliminary degree was passed on it.
Then what is it?
I have filed one IA for stay of the judgment. Only notice was issued in the IA notice.
Day of what judgment?
The preliminary degree and final degree, both the degree was passed by in the partition. I have challenged the preliminary degree with a condemnation application. That condemnation application was allowed, appeal was admitted for hearing, and thereafter appeal was dismissed.
Thereupon,
First appeal was dismissed. Against that, I have challenged. Second appeal already admitted,
your condonation application was dismissed.
allowed. Condemnation was allowed, appeal was admitted for hearing, and thereafter, lordship, the appeal was dismissed.
Now, why do you want this? What do I do? Yeah,
Title execution procedure.
execution proceedings, right?
It is the daughter and we are the four brothers. Lordship. The share was given 50% to the plaintiff, and she is entitled only for 1/9 as per nominal law. Four brothers, lordship, each of them will take 2 shares, and she will take only 1 share.
Why the trial, first appellate court did not look into it?
First appellate court held that they was condemned, appeal is admitted for hearing. And thereafter, while deciding the appeal, we take the section 97 was misappropriated. As per section 97, if we not prefer any appeal challenging preliminary degree, that cannot be taken into a ground of the appeal against first appeal. But we have preferred the first appeal against the preliminary degree, along with the condemnation appeal. Final degree, we have not challenged. That I tell you. By that time, final degree was already passed.
Partition done, so soon.
Already they have initiated the execution.
Then how did the final degree come to be passed?
Share was only partition. Partition was not done.
Then how can there be a final degree? Yes, Mr. Sigdar.
Wrong, my lord.
No,
My lord, there are
something is wrong.
preliminary degree, they have not whispered at all about the preliminary degree. Time has appeared, then my lord, first appeal, my lord, that was also filed beyond time. Well, independent execution is, has been done.
Then?
The preliminary degree, they have not, well, even if the preliminary degree is not challenged during this period, then, how that, my lord, the execution can be, my lord, challenged. And, final appeal is ultimately failed. Because they have not challenged the preliminary degree.
They have challenged the preliminary degree.
Condemnation is on, my lord, appeal, first appeal, not preliminary, appeal against preliminary. No appeal from against preliminary.
It's 69 of the appeal.
it?
Page 69, rejection 7. Third paragraph proceeding the petition filed under section 5 of the Litigation Act for conservation of delays to file the title appeal against the judgment dated 7/3/19 in title should be case number 31/2014, wherein it is stated that the accused judgment and order was passed by the London Trial Court on 7/3/19, but the engaged counsel for the appeal of the results lordship.
So what is the date of the preliminary decree?
That is the date, lordship, 7/3/19, and final decree date lordship 22/2/2022.
So you prepared the preliminary decree challenge only after the final decree is passed.
With a condemnation element. That condemnation is allowed, lordship, page 71. With a cost of rupees 2,000.
Only. Yeah,
Appeal is admitted for hearing.
appeal is dismissed without cost. Because this is a stingy judge. Hmm. So let them-
Page 84 is the finding.
whether the judgment and decree passed by the learned. To 97. Now what do you want? What is the execution? Where is the final degree?
Next date is 13/5/2025. Final decree I have enclosed.
Where?
Page 54.
Page
54.
54.
Then under our position.
So it has been done, everything done. What is there to stay?
And now there are study of position.
Fantastic, good.
Already my evidence admitted.
Appeal has been admitted
Executive
to,
court,
we'll see when the matter. You can go for an early hearing. So,
All the
nothing
respondents,
more than, there's no stay business.
if the executing court is saying that
Why were you sleeping on the wine?
already lordship RSA was admitted, there is no stay. of the-
Fantastic. When that person was the judge was a very stingy judge. He allowed it in
Degree
2000.
itself is a wrong degree, lordship. She was
Who was?
50% of the property.
I'm also
He
taking
is
it from
only
the court has
entitled for
nothing to
1/9 of the property.
We are only on a substantial question of.
Because
When do
already.
you want, you can go for an early dispute.
Lordship can dispose it of the
The
entire-
sorted matter is a hard one, damn, I agree.
Next date is 13/5. Before that, any date. Execution is on 13/5.
Leave the matter on 6/5/2025. Records are here. Taking into account that the records are here. Records are there, respondents are duly represented. List the matter for hearing on 6/5/2025. List the matter. liberty given to both the parties, mention them.
Okay. 27.
Yes, any urgency? I'm writing at 4:45.
I will show you the secretary meeting. It's really discussed in my paper. And my I think.
What do you want? What do you want?
It is very decreased in my paper.
Who did you have one doing? What do you want?
Now, my eviction proceeding is going on. As far as state
Hey, get your dates whenever in time order to be extended.
Item 33, my lord. Item number 33 in IA 1427.
Previous 33 business.
Item that injunction was passed. So that order. Respondents have filed an application for stay vacating. Respondents have filed an application for stay vacating. So those are, my lord, is 2516 and 263.
We'll have it next Monday. This is the matter in item number 33. 33, ne?
Yes, sir.
33. We listed on 28th of April 2025.
Get him to continue.
Came on the past earlier shall continue. I think.
Amended cost items, but lordship agreements are not providing the amended cost items of.
No, madam, it has not yet been admitted. We have no business.
Our name.
Absolutely no.
State
No.
payment.
Are you on caveat?
Oh, lordship.
You don't.
I included myself as lordship.
If you are, why have you included?
Lordship, the
It is only impleading when you implead yourself means there's something wrong with the council.
On that person. So the being legal heirs, we pleaded ourselves in fixed state lordship.
You see out there, whenever a matter comes, we'll have it, we'll have it on. The 9th of May.
Okay, may I please know?
Yes.
Please, my lord, yes, sir.
What is that?
Degree was executed and here they have filed a condolence petition of to delay the 861 days. That is allowed. So we have
You are for whom?
with the evidence. Original evidence place.
So,
So that's the
on 28th, okay. Have it on 28th, 28th. Wait. 28th, 4.
that is not.
8th.
Item number 14 is regarding demarcation of land lordship.
Item number?
40. So lordship directed us to file a contempt case. So we have filed the contempt case also.
Ah.
That was listed before the Honorable Court 17 and Honorable Court has tagged this matter along with this I.
Item 40 and 41 to be listed on 20. 30. 34. Okay, you, for dates, you take it from them. I'm nothing to do.
My lord, item 46,
Any interim order is to be passed, you tell me. Otherwise, don't.
item 46, there is an interim order that will be extended.
Item
46. I have 1980.
interim order is there.
Interim order. There is a substitution petition also filed. My lord, whether is what?
In number 46. Is the matter again on 2nd of May 2025.
Can it be on 5/5? Second and fourth. 5/5.
2nd of May 2025. I can have it on 5/5, but interim order shall only be till 2nd, okay? No, 5/5, but I'll have the interim order only till 2nd. This is the matter on 5/5/2025. However, the interim order passed earlier shall continue only till 2/5/2025.
Then my lord, let's take up on 2/5.
2/5. 2/5, yeah.
Because my lord, actually on 2/5, I was not in station, so.
So the
What
be in station or there.
Come in, my lord. If there are item 32, there is an interim, my lord, that may be continued.
It is a DD, but it's.
32.